मैं important to मैं yes.
I beg pardon to mention, my lord, two bail methods, my lord. According
मैं important to mention that Chief, I have filed an IA for conversion of CRL to PLPL.
Tied up
Tomorrow.
matter and another CLA.
Hmm?
Tied up bail matter.
Give it.
tied up and bail 3 assist.
Give it.
Lords, I may be pardoned to make a mention, a tied-up matter, but although as per the last standing order, it was listed on 6/7/2023 before Honorable Justice Rautray, who has recused to hear the matter and directed the matter to be placed before my lord.
Okay, give it. Give it.
Lords, may I pray? Maybe
Yes, give it.
grateful.
On bail matter, man.
Give it.
Pardon to mention, my lord, this is CRLM IA for the appellant on medical ground.
Give it.
Tied up.
Re-assist appeal.
A tied up matter. Another is a criminal appeal for bail. And another also hearing matter.
Case admission, criminal appeal matter.
A tied-up bail matter.
Tied up bail.
Give it.
I may pardon, my lord, praise admission 119 SCST notice should go. Maybe taken up, my lord. 619.
Issue notice. Extra copy to be served by.
Just now I am serving, my lord.
102 also, your lordship, SCST.
119.
Yes, my lord.
Just a minute. 119 notice to be issued. Extra copy. Yes.
202, 202, your lordship. 202, same. 3 SCST there.
202.
Yes, lordship.
202 also same matter. But downloaded copy of so okay. Extra copy notice. All right. CDCH. Yeah.
Pardon to mention, my lord.
Yes.
Item 225. There are wrongly mentioned one bail number, my lord. 316 of 2022 में other कोआकी जेलियर कोआकी डिस्पोज बाय जस्टिस शशिकांत मिश्र में DLPL number 981121 3832
Which is the item number?
Item 225, my lord.
Just a minute.
My offense is NDPS, my lord. Disposable IPC matter.
225 is a CRLA for fine, stay of realization of fine and bail. So it's a case of conviction. CRLA number 93 of 2022. Yes.
Sorry, my lord. 4 तारीख को date रहा
Yes, next. Call.
Weekly list item 1.
My lord, the appellant sentenced to convicted and
Three 451 and 34 IPC. SI for 1 year, my lord. And there is a fine of 500 rupees.
You are on bail?
Yes, my lord. He has granted bail.
Admit bail granted, stay realization of fine.
Obliged.
Item 4.
My lord, the offer.
And at conviction under section 20B 2C of NDPS Act, my lord, rigorous imprisonment and 10 years and to pay fine up to 1 lakh.
All right, admit call for the trial court report. Interim applications for bail and stay shall be considered after receipt of the trial court report. The position copy to be supplied to the State Council.
Item 6.
Item 6, the appellant is convicted under Section 7 of PC Act, read with 13(1)(d) and 13(2) of PC Act for the period of 3 years, my lord. Relevant page is 48.
48 running page or internal page?
Internal page, my lord.
Internal page. I convict you are Brajabandhu Sethi, okay?
Brajabandhu Sethi.
Undergo RI for 2 years, fine 5,000. In default to undergo RI for 3 months, 7 PC Act. Then RI for 3 years, 5,000. In default to undergo so and so under 13(1)(d), 13(2). Round concurrently. So it's 3 years.
My lord.
You are on bail during
Bail,
that. Yes, Mr. Das.
Yes, my lord. I will file my appearance memo by the end of August, my lord.
All right. Admit he was on bail. Bail granted. Stay realization of fine. Mr. Das submits that he will file the appearance memo by end of August. Name of Mr. Sanjay Kumar Das be reflected in the cause list henceforth. Yes.
Obliged, my lord.
Item 7.
Free copy of the order.
Free copy of the order. Okay. Yes.
Item
Obliged.
7.
May I please, your lordship? Your lordship, the appellant is challenging the judgment of conviction and order dated 22/7/2023. Your lordship.
What is the operative part of the judgment? Page number?
Your lordship, page 64. Your lordship.
Running page or internal
Running
page?
page, your lordship.
Running page 64. Wait. Your name is Jagannath Pani.
Your lordship, my name is Anubhav Moharana.
Huh?
Anubhav Moharana.
No, the petitioner, the appellant's name. Jagannath Pani is
Yes,
sentenced to undergo RI for 3 years and pay fine of rupees 5,000. In default to undergo RI for 2 months under 7 PC Act. RI for 1 year. 1,000, 1 month, 13(1)(d) concurrent. So it's 3 years.
Yes, your lordship.
You are on bail during trial.
Yes, your lordship.
Okay. Yes, Mr. Das.
Yes, my lord. I have received. Same. I will file my appearance memo by the end of August.
Same order. Admit bail granted. Stay realization of fine. Will file the appearance memo by end of August. Free copy. Yes.
Obliged.
Item 8.
This is an
Condonation of delay. What is this criminal appeal for?
appeal for being appealed by the judgment by the Lord and PO S.C.ST Act of Kotak, my lord.
Case of conviction.
My lord, acquittal.
Oh, acquittal. All right. So, you are the informant.
My lord.
Okay. What is the delay here?
36 days.
36 days. So, notice has to go. File your requisites. Issue notice on the question of limitation. Requisites or issuance of notice on the. How many opposite parties are there?
Hello.
Opposite parties number 2 and 3. By registered post with ready be filed by within during course of this week. List this matter for order on the IA after the notice is made sufficient on OP 2 and 3. Extra copy of the appeal memo be served on the Land and Council for the state. Yes.
Item 10. Item 11.
May I please?
Yes, Mr. Mahanti. What is the defect? 5D means state copy.
State
You have
copy.
received the copy, Mr.
No, Lord,
Tripathi?
sir.
Yes, Miller. Yes, Miller.
What is this criminal appeal for?
Your Lordship, the appellant is acquitted from the offences 294506 and 31X and 31X SC and STO Act, Lordship. Here the London Trial Court has extended the conviction under section 323.
You have been found guilty under 323. What is the sentence?
There is no sentence, but the
PO Act, you have been left out.
Lordship. Only the administration has been favored by the London Trial.
No, it's all right. You can challenge it.
Lordship.
But once you are released on PO Act,
Lordship.
there is a provision, separate provision under PO Act to file the appeal.
All.
So please show it that PO Act. Probation of Offender Act. Have you brought that PO Act with you? ऐसे जो ये टा खोलो, से EBC टा खोलो. जो ऊपर लिखा सर्च रे PO Act लिखा. PO Act. लिखो Probation of Offenders Act लिखो पूरा टा. PRO PA for Bombay.
No.
That's click it. It has just you see that is section 11. Courts competent to make order under the Act, appeal, revision, and powers of the court in appeal or revision. Notwithstanding anything contained in the code or any other law, an order under this Act means PO Act, may be made by any court empowered to try and sentence offender to imprisonment, and also by High Court or any other court when the case comes before it in appeal or in revision. Notwithstanding anything contained in this Act, where an order under section, just listen it, notwithstanding anything contained in this code means criminal procedure code, when an order under section 3 or section 4, this order has been passed under section 3, is made by any court trying the offender other than the High Court, and appeals shall lie to the court to which appeals ordinarily lie from the sentence from the former court. So this should be an appeal under section 11(2) of the Probation of Offenders Act, right? So you are to just amend it and insert that position. All right, admit the London Council for the appellant seeks permission to insert the relevant provision of the Probation of Offenders Act in the cause title of the appeal memo. Prayer is allowed. Admit, call for the trial court record. Yes.
I for stay.
Huh?
Stay for the.
But what order has been passed? There is nothing, I think,
The admonition.
admonition is just given. You have been convicted, so ultimately, if you are acquitted, all right, nothing has gone now against you to pass an order of stay. Okay, ଆପଣଙ୍କୁ କହିଲେ ଆଉ ଏମିତି କରିବନି ଏଇଆ କହିକି ଆପଣଙ୍କୁ ଛାଡ଼ିଦେଲେ, so that's all. So but still then conviction remains there, so ultimately in the appeal it is to be decided whether the conviction will remain or not. Okay, all right, so you file you will make necessary. 374 जोटी लिखा है ता साइड रे and section 11 bracket रे 2 of the POR. Okay, yes, next.
Item 12,
offense is under section 302.
In this case, I have received only appeal memo. No documents, no rejection order, nothing is there.
କଣ କହୁଛନ୍ତି?
Convert ହେଇଥିଲା
ବେଲ୍ ଆପ୍ଲିକେସନ ବଟ୍ ସେ କନଭର୍ଟ ହେଲେ ସେ ସିଆଡେ ରହିଲା, ଆପଣ କପି ଦିଅନ୍ତୁ ତାଙ୍କୁ ରିଜେକ୍ସନ ଅର୍ଡର। ଦି ଲ୍ୟାଣ୍ଡ କାଉନ୍ସିଲ ଫର ଦି you have not received the case diary, Mr.
No, my lord, there is nothing there. Only appeal memo.
SCST appeal or what?
Madam?
SCST appeal.
Madam.
Notice has been issued.
No, my lord. The first time it has come. And there is defect are there.
Defect number 9 is there. That is not a major defect. Let us see that what is the defect. Defect number 9. Good ground certificate is slot. The Land Council for the state submitted that he has only received the appeal memo, but not the annexures to the appeal memo. Let the Land Council for the appellant supply the same to the Land Council for the state by tomorrow, Kuchi.
In course of day, I will.
Or in course of the day. Extra copy of the appeal memo along with annexure be served on the Land Council for the state. Usual order. 1 week after, you will obtain the case diary and criminal antecedent, if any. In the meantime, what is the offense here? Apart from SCST,
302.
offense?
302, 201.
302.
All right, all right. Serve the extra copy and also the annexures copy to the Land and State Council.
Right.
Next.
Item 15.
On the basis of the FIR.
Somebody has entered appearance.
Well,
You are there. And Mr. Tripathi, you have received the case diary?
Yes, my lord.
Okay.
on the basis of
Wait.
the FIR last by
Just a
one-
minute. This is item number 17. PRLA 514/2023. Okay. You are in custody since when?
My lord, I am in custody since 1/3/2023.
23.
My lord,
Charge sheet submitted.
charge sheet submitted.
Under what offenses?
Charge sheet submitted in an offense under section 302/201,
302/201,
120B,
120B.
109 of the Indian Penal Code,
Yes.
read with section 25-27 of the Arms Act,
Hmm.
and 32VA,
32VA,
32V of the SSTPA.
V and VA. Okay, CST. And what is the name of the deceased?
My lord, name of the deceased is Tanu Kurei.
Huh?
Tanu Kure.
Tonu.
TANU.
Huh?
KURE.
Huh?
KURE. Tanu
K-
Kure.
KURE.
My lord.
Okay. Date
Why?
of occurrence.
My lord.
Date of occurrence.
Date of occurrence, it is alleged that in the FIR, the informant found a dead body which is lying.
No, date of occurrence has been given in the FIR as a column number 3.
In the FIR that was not given, but in the
Yes, a dead body was found.
my lord,
Okay, then what happened?
during the course of investigation, it is ascertained
That it is the dead body of this Tonu Kure. All right, then what happened? What are the materials against you?
Sachin Agrawal has some relationship with the deceased. Accordingly, the Sachin Agrawal.
This deceased is a lady?
My lord.
Okay. Sachin Agrawal.
Sachin Agrawal and Tanu Kure was some relationship. Accordingly, on 22/11/2022, they had came in a car where the Sachin along with others have committed the murder. Though the name of the petitioner does not find place in the FIR, but during the course of investigation, it is ascertained that earlier the present petitioner and the Sachin Agrawal were.
Pastor, tell me that whether there is any eyewitness to the occurrence.
No, admittedly
No
there was
eyewitness. Then it's a case based on circumstantial
My
evidence.
lord.
What are the circumstances against you?
Only except the confession of Sachin Agrawal, there is no material against
Sachin is a co-accused in this case.
My lord, he is the principal accused.
Co-accused confession before whom?
Before the police.
From so far as you are concerned,
No.
there is no other material.
No other.
Last seen,
No.
usually in a case of circumstantial
No.
evidence, it happens. And last scene is not there.
Extrajudicial confession is there.
Acha, before whom? Before whom?
Before one, Hiralal Niala.
Hiralal Niara.
Nial.
Hiralal?
Nial.
Acha. Nial, okay. Not in the presence of police. It's a extrajudicial. No. Please read it out.
Yes, madam. I am reading relevant portion. Ramesh ସମ୍ପର୍କରେ ସଚିନ ଅଗ୍ରୱାଲ ପିୟୁଷ ହେବେ ତଣ୍ଡିପାଲି ଗାଁର ଲକ୍ଷୀଧର ବିଶି ମୋ ସାଙ୍ଗ ଅଟୋ ସଚିନ ଅଗ୍ରୱାଲ ସହ ଆମ ଦେଖା ହେବା ସମୟରେ ଆମକୁ ତାଙ୍କ ସହ ଗଞ୍ଜେଇ ବେପାର କରିବାକୁ ସବୁବେଳେ କୁହନ୍ତି ଓ ସେମାନେ ବହୁତ ପଇସା ମିଳିବ ବୋଲି କୁହନ୍ତି। ସେ ଆମକୁ ଛୋଟ ଛୋଟ କାମ କରିବାକୁ କୁହନ୍ତି ଓ ତା ପାଇଁ ପଇସା ମଧ୍ୟ ଦିଅନ୍ତି। ମୁଁ ସଚିନକୁ ପ୍ରାୟ 2 ବର୍ଷ ହବ ଜାଣେ। 21/11/22 ତାରିଖ ଦିନ 12:30 ବେଳେ ସଚିନ ଅଗ୍ରୱାଲ ମତେ ଫୋନ କରି କହିଲା ତା ଗାଡି ଧୋଇବାର ଅଛି ଓ ଗୋଟେ ବାଲ୍ଟି ଓ ମଗ ଧରି ଆସିବାକୁ କହିଲା। ମୁଁ ବାଲ୍ଟି ଓ ମଗ ଧରି ବେହେରା ଗାଁ ଛକକୁ ଗଲି। ସେଠାରେ ଦେଖିଲି ଯେ ସଚିନ ଅଗ୍ରୱାଲ ସେ ତାର ଏକ ଦିଲ୍ଲୀ ନମ୍ବର ଥିବା ଧଳା ଡଷ୍ଟର ଗାଡିରେ ଗାଁକୁ ଆସିଲା। ମତେ ଗାଡିରେ ବସିବାକୁ କହିଲା। ମୁଁ ଗାଡିରେ ବସିଲା ପରେ ନଈ ପାଖରେ ଥିବା ନଈକୁ ଗଲୁ। से धरिଥିବା गोटे छोट सैमसंग कीपैड मोबाइल मते धरिବାକୁ କହିଲା। ମୁଁ ସେ ମୋବାଇଲ କୁ ପକେଟରେ ରଖିଲି। ତାପରେ ମୁଁ ଗାଡିରୁ ବାହାର ପଟୁ ପାଣି ମାରିଲି। ତାପରେ ସେ ଗାଡିର ଡୋର ଓ ଡିକି ଖୋଲି ମତେ ଧୋଇବାକୁ କହିଲା। ମୁଁ ଯାଇ ଦେଖିଲୁ ଗାଡିରୁ ଗାଡିର ଆଗ ପଛ ଡିକି ସବୁଆଡେ ରକ୍ତ ଲାଗିଛି। ମୁଁ ଓ ମୋ ସାଙ୍ଗମାନେ ଗୋଟେ ଟୁକେଲକୁ ମର୍ଡର କରିଦେଇଛୁ। ଆଉ ତୁ ମତେ ହେଲ୍ପ କର ବୋଲି ସଚିନ କହିଲା। ତୁମେ କାଣ୍ଡ କରିଛ, ମତେ ଫସାଉଛ ବୋଲି କହିଲା। ମୁଁ କହିଲି ମୋ କହିବା ଅନୁସାରେ କାମ କରିବୁ, ନହେଲେ ତତେ ଗୁଳି ମାରିଦେବି ବୋଲି କହି ପିସ୍ତଲ ଦେଖେଇଲେ, ଡରେଇଲା। ମୁଁ ଡରି ମରି ସବୁ କରିବି ବୋଲି କହିଲି ଓ ପଛପଟ ଧୋଇ ବ୍ୟସ୍ତ ଥିବା ସମୟରେ ମୁଁ ସେଠାରୁ ଲୁଚିକି ପଳେଇ ଆସିଲି।
No, it's all right, Mr. Tripathi, but that is the confessional statement of that Sachin. The petitioner is Chandan Kumar Singh. The petitioner is not Sachin.
Involvement is only confessional statement.
But that he is telling that. You say that no,
yes,
he also confessed.
That's true. That's
Okay.
true.
So there is no other material against this petitioner.
No.
What do you say?
No.
Heard the learned counsel for the appellant, learned counsel for the state, and learned counsel for the informant. The learned counsel for the appellant submitted that the appellant is in judicial custody since 1/3/2023, and he has been charge sheeted under section 302(201), 120B, 109 of the Indian Penal Code, 25 and 27 of the Arms Act, 3(2)V, another bracket BA of the SC/ST/PO Act. It is further submitted that it's a case where there is no direct evidence against the petitioner, against the appellant, and the case is based on circumstantial evidence, and the only circumstance available against the appellant is the confessional statement of co-accused Sachin Agrawal before police, in which he has implicated the appellant, and in view of the available material on record, the bail application may be favorably considered. Learned counsel for the state, on the other hand, produced the case diary and submitted that the co-accused Sachin has also made extrajudicial confession before one Hiralal Niyal, and he placed the statement of the said witness. However, the learned counsel for the state also submitted that there is no other material except the confessional statement of the co-accused. The learned counsel for the informant also doesn't dispute about the submission made by the learned counsel for the appellant. Considering the submission made by the learned counsel for the respective parties, the nature of accusation against the petitioner, absence of any direct evidence, nature of circumstantial evidence on record, since the only material available against the petitioner is the confessional statement of co-accused, either before police or before the witness Hiralal Niyal. Taking into account his period of detention in judicial custody, I am inclined to release him on bail. Shall appear before the learned trial court on his date. The case should be posted for trial. Shall not indulge in any criminal activities, not try to tamper with the evidence. Violation of any terms and conditions shall entail cancellation of bail. Yes, allowed.
Item 18. Item 19.
Mr. Chand,
Mr. Chand, next week, my lord.
next week. Your senior got elected or it has not been finalized? Bar council election. You do not know. All right. As grateful is this matter on 7/8/2023. Yes.
Item 20.
20 minutes seeking for an adjournment that will come after 2 weeks, my lord.
What is this defect, madam? Defect number 7.
My lords, the defect maybe regarding the translated copy, my lords.
7. Okay. Would not correctly indicated. All right. You have received the case diary, Mr.
Yes.
Patel?
No, my lord, this is a complaint case.
No, what is this criminal appeal for?
Protest petition.
My lords, this is the matter where there was the faculty member raised certain allegation regarding against the principal, my lord. My senior Mr. Sharma was conducting the case, and because SC/ST allegation is involved, so it is named as CRLA.
In the main case, it was filed that the charge sheet filed as a false case.
Yes, my lord.
Okay, then
No case was made
protest
out.
petition was
Then
filed
protest
and
petition.
cognizance of offense has been taken. One of the
Yes.
offenses 3 SC/ST Act, right?
Yes, yes, my lord.
So what about notice? Notice has been issued or not?
No, yes,
my lords,
notice
notice has
issued
been
and
issued
served
and
on
copy has been
11/7/23.
Okay. The London Council
Egar-
for the State submits that notice on the informant Gopal Chandra Behera has been made sufficient on 11/7/2023. None appears for the appellant. Stop.
I'm for the appellant, my lord. I'm on behalf
None
of
appears for the informant. Mention is made on behalf of the Land Council for the appellant. You want adjournment
Yes, my lords.
to adjourn the matter? Want it next week?
Next week or 2 weeks after, my lords.
Any stay has been granted? All right. As prayed for, list this matter in the week commencing from 14th August 2023. Yes.
Obliged, my lords.
Item 21. Item 22.
Yes.
I plead loss, my lord.
What is the CRLA for?
That is appeal against the SC Act, my lord. For
Yes,
illegal
bail.
bail.
CD available?
Yes, my lord. CD
Okay.
notice has been served.
No, that he has already appeared. So
Yes.
this is CRLA 643 of 2023. What is the date of custody?
8/11/2022, my lord.
Huh?
8/11/2022.
8/11/2022,
22.
right? What are the offenses under which charge sheet submitted?
Charge submitted under section 364, 302,
364, 302.
201,
Yes.
120B,
Hmm.
and 32V, VA and SC/ST Act.
V and VA.
Yes,
SC and ST Act. Okay. What is the name of the deceased?
my lord.
Hiteshwari Naik.
Hiteshwari.
Hiteshwari. Lady.
Hiteshwari Naik.
Yes, my lord.
Hiteshwari Naik.
N-A-I-K.
N-A-I-K. Okay. Date of occurrence?
Date of occurrence, my lord, 6/1/2022.
6/11.
6/1, my lord, January.
Oh, you are arrested on 8/11. Okay. 6/1/2022.
FR lodged on 9/1/2000.
What are the materials against you? Eyewitnesses are there?
No eyewitness, my there.
No eyewitness. Then what are the materials against you?
Matters against the present petition only. Two eyewitness confession, man, only, my lord.
No, if FIR against unknown person.
No, my lord, FR against.
Yes, unknown person.
FR against unknown person, my lord.
Okay. Who has lost the FIR?
Other of the deceased, my lord.
Dhaniram Naik,
Yes.
okay. Father of deceased. What he has stated, please come to that FIR.
ମୁଁ ଧନିରାମ ନାୟକ, ପିତା ଯୋଗୀରାମ ନାୟକ, ଗ୍ରାମ ରତିପାଲି, ଜିଲ୍ଲା ନୂଆପଡ଼ା ଅଟେ। ଗତ 6/1/22 ରାତ୍ର 12ଟାରେ ଦେଖିଲୁ ଯେ ତାର ଖଟ ଖାଲି ଥିଲା। ସାଙ୍ଗେ ଆମେ ଆଠ ପାଠ ଖୋଜାଖୋଜି କଲୁ। 7/1/22 ତାରିଖ ଦିନ ଆମେ ପରିବାର ବର୍ଗ ଗାଁକୁ ମଧ୍ୟ ଖୋଜାଖୋଜି କଲୁ, କିନ୍ତୁ କୌଣସି ପତ୍ତା ପାଇଲୁ ନାହିଁ, ମିଳିଲା ନାହିଁ। ପରେ ନିରାଶ ହେଲୁ। ତାପରେ 9/1/22 ଦିନ ନୂଆପଡ଼ା ଥାନାରେ ଲିଖିତ ଅଭିଯୋଗ କରୁଅଛୁ। ଏଇ ବିନୀତ ପ୍ରାର୍ଥନା ରହୁଛି ମୋର ଝିଅ
ତାମାନେ ଝିଅ ଘରୁ ମିସିଂ କରୁଥିଲା, ସେଥିପାଇଁ ରିପୋର୍ଟଟା ହେଲା।
ଆଜ୍ଞା।
ଅଲ୍ଟିମେଟଲି କଣ ହେଲା, ତା ଡେଡ୍ ବଡି କୋଉଠି ମିଳିଲା?
Ultimately, the peoples are reading the statement of the Kartik Naik, my lord. Kartik Naik, the person, he was stated to the Dhaniram, my lord.
First, tell me from where the dead body was recovered, because it's a case under 302.
Dead body recovered from a cultivation field, man.
Okay. On what date?
On date, my lord, 11 range बोले हला।
Huh?
11 month बोले।
In the month of November, the dead body was recovered. Are you sure?
Yes, man. Kind of statement होची 26/10
just November from a field. So if there are no eyewitness, then what are the circumstances?
I stated reading the statement of the Kartik Naik, my lord, who is the person informed to Dhaniram, my lord, about the incident, my lord.
Just Kartik Naik.
Yes, my lord.
Yes, what he has informed to the father of the deceased?
ଆମ ଗ୍ରାମର ଧନିରାମ ନାୟକ ଝିଅ ହିତେଶ୍ୱରୀ ନାୟକ 3/1/22 ତାରିଖ ଦିନ ରାତିରୁ ଘରୁ ନିଖୋଜ ହୋଇଯାଇଥିଲା। ଗତ 5-7 ମାସ ତାକୁ ବହୁତ ଖୋଜାଖୋଜି କରିବା ପରେ ମଧ୍ୟ ତାର କିଛି ପତ୍ତା ମିଳିଲା ନାହିଁ। 26/10/22 ତାରିଖ ଦିନ ମୁଁ ଝିଲିଲା ଗାଁର ବିହାରୀ ସାହୁଙ୍କ ଠାରୁ ଶୁଣିଲି ଯେ ଝିଲିଲା ଗାଁର ପିଲାମାନେ ହିତେଶ୍ୱରୀକୁ ମାରି ଦେଇ କେଉଁଠୁ ପୋତି ଦେଇଛନ୍ତି। ସନ୍ଧ୍ୟାରେ ଧନିରାମକୁ ଭେଟି ମୁଁ ତାକୁ ଏକଥା କହିଲି। ଏକଥା ଶୁଣିବା ପରେ ଧନିରାମ 27/10/22 ସକାଳ 8ଟା ସମୟରେ ଆମ ପଡ଼ାରେ ଗୋଟେ ମିଟିଂ ଡକାଇଲେ। ଉକ୍ତ ମିଟିଂରେ ଧନିରାମ ନାୟକ, ତାଙ୍କ ସ୍ତ୍ରୀ, ପରିବାର ଲୋକ, ମୁଁ, କହ୍ନୈୟା ନାୟକ, ହୀରାଲାଲ ନାୟକ, ଭୀମସେନ ନାୟକ, ମନୋଜ ନାୟକ, ଦଶମନି ନାୟକ, କମଳ ନାୟକ, ମହେନ୍ଦ୍ର ନାୟକ, number of persons are there. ଉକ୍ତ ମିଟିଂରେ ଝିଲିଲା ଗାଁର ବିହାରୀ ସାହୁକୁ ଡକାଇବାରୁ ସିଏ ଆସି କହିଲେ ସେ ଗତ କିଛି ଦିନ ହେବ ତାଙ୍କ ଝିଲିମିଲା ଗ୍ରାମର ଲୋକମାନଙ୍କ ଭିତରେ ଫୁସୁରୁ ଫସର ହେଉଛନ୍ତି ଯେ ଇତେଶ୍ୱରୀକୁ ତାଙ୍କ ଗ୍ରାମର ସୋନୁ ସାହୁ, ବସନ୍ତ ରାଉତ, ବନମାଳୀ ଆଲିଆସ ଗଣା ବାବୁ ରାଉତ, ଡମ୍ବରୁଧର ଆଲିଆସ କାହ୍ନୁ ରାଉତ,
petitioner.
yes madam, ଲୋକେ ସବର and ଚିକୁ ବିଜୟ ସବର ମିଶି ମାରିଛନ୍ତି। ଉପରେ ତାପରେ ଧନୀରାମ ଧର୍ମେନ୍ଦ୍ର ନାୟକ ମିଶି ଝିଲିମିଳା ଗ୍ରାମକୁ ଘଟଣା ବିଷୟରେ ଜାଣିବା ପାଇଁ ଯାଇଥିଲେ। ସେତେବେଳେ ପୋଷ୍ଟ ଅଫିସରୁ ଗୋଟେ ବେନାମୀ ଚିଠି ଧନୀରାମ ନାୟକଙ୍କ ପାଖକୁ ଆସିଥିଲା। ସେଥିରେ କିଏ କିଏ ହିତେଶ୍ୱରକୁ ମାରିଛନ୍ତି ତାହା ଲେଖା ଥିଲା। ତାପରେ ଧନୀରାମ ଧର୍ମେନ୍ଦ୍ର ସୁମିତ୍ରା ନାୟକ ଉକ୍ତ ଚିଠି ଧରି ସନ୍ଧ୍ୟାରେ ନୂଆପଡା ଥାନାକୁ ଯାଇଥିଲେ। ପୋଲିସ
So,
ଝିଲିମିଳା
all right. Any other material?
Thereafter, my lord, only confession of the accused of the Paramananda alias Sonu Sahu, who have the love relation with the Hiteshwari, and he has, as per the statement of the accused confession, my lord, he has
Montana Sonu Sahu.
Paramananda alias Sonu Sahu.
Paramananda.
ଯେ 4 ମାସରେ ସେ ଗର୍ଭବତୀ ହୋଇଥିଲା ବୋଲି କହିବାରୁ ସେମାନେ ଓନ୍ଲି ଆମ ଏଗନେଷ୍ଟ ଅଛି ଡମ୍ବରୁଧର ଓ ବନମାଳୀ। ଡମ୍ବରୁଧର ପ୍ରେଜେଣ୍ଟ ପିଟିସନର, ବନମାଳୀ ରାଉତ ହତ୍ୟା ଷଡ଼ଯନ୍ତ୍ର ସାମିଲ ଥିଲେ, କିନ୍ତୁ ଆକ୍ଚୁଆଲି ହତ୍ୟା କରିଥିଲେ।
What is the PM report?
ନା ଯୋଉ ଷ୍ଟେଟମେଣ୍ଟ ଆଉ ଟୁ କନଫେସନ।
अरे पोस्टमार्टम रिपोर्ट और फाइंडिंग कौन डेथ ऊपर है। What is the cause of death as per the PM report? Whether there is anything to show that the deceased was pregnant
Lordship,
for 4 months.
No, Lordship. That part is missing because after around 10 months, the dead body was recovered from a paddy field. 10 months. And the cause of death, as per the doctor's opinion, in the PM report says that there is no definite finding to suggest the cause of death due to skeletonization. However, considering
so
the
skeleton was recovered.
Yes, Lordship. Yes, that is what.
Oh, I see.
And however, considering the position of the nylon rope, ligature material, and the pattern of its disposition, homicide strangulation could be the most probable cause of death. That is what the report. And it's a other thing may I submit, Lordship?
Yeah.
Lordship. Here what happened, Lordship? 6 persons. They had a plan. One strong conspiracy was made to kill the deceased. Background of the story is that Paramananda Sahu.
Don't tell me the story.
Lordship,
if you say conspiracy, what are the materials for that?
I'm coming, Lordship. Paramananda Sahu, the prime.
Who is the witness to the conspiracy?
Witness, Lordship.
Anybody has seen, heard that these persons were conspiring together to kill the deceased? Or the IO has written in the case diary that there was conspiracy?
Case diary part I cannot say, but I do have the documents. Which
what is the conspiracy? You tell that
I'm coming.
You submitted
Lordship,
that it's a case of conspiracy.
Lordship,
I'm asking you that who is that witness, or what is the material that they conspired together?
The material is that in that confessional statement of the
so that is also confessional statement.
Lordship, Paramananda Sahu,
all right,
the prime accused. There he says, may I read, Lordship, relevant portion?
No, you are reading a statement made before police. In that confessional statement, the conspiracy part is there.
Lordship.
That's all.
That's
anything else?
Anything else, Lordship? Because it's a case based on circumstantial evidence, Lordship. After around 10 months, the dead body was recovered from a paddy field, and the accused persons belong to one Jilimili Grama village, from where there were some talks in between the villagers that some portions of the villagers, they have killed one girl child. And basing upon that, one Bihari Sahu, he informed to the concerned informant, that is father of the deceased, that some person are talking that they have killed your daughter, and accordingly you may go for that. And when he inquired about the matter and convened a meeting in that village, there this informant found that these 6 accused persons, they conspired among them, and they made out a plan. The Pawan Sahu killed the deceased by means of a rope, and thereafter 4 accused persons, they took the dead body to the concerned near paddy field.
All right, to what you are submitting, that even it is the prosecution case, let us say as per that confessional statement of co-accused, that Paramananda alias Sonu Sahu he had love affair with the deceased, right?
Right, Lordship.
And the deceased was 4 months pregnant
By that time.
And it is he who has killed the deceased, and it's a case of manual strangulation, let us say. And your case is that so far as the petitioner is concerned, or the appellant, he has conspired with that Paramananda alias Sonu Sahu and other co-accused person. That is the entire thing. But that is based on the confessional statement of co-accused.
Right, Lordship.
Yes, Mr. Tripathi, anything else?
Yes, so 164 statement of Gajendra Harijan. May I read, Miller?
Yes.
Yes. पुलिस धनीराम नायक झील हितेश्वरी नायक कुआडे हजि जाइछि बोली मु शुणिथिली किंतु तार किछि दिन परे गाँर किए जने कहिला झील को किछि जन मिसी मारिकी पुति देइछंती तापरे धनीराम को गोटे अजଣା चिठी आसिला जहाँकि हिंदी रे लेखा थिला सेटारे सोनू साहू बसंत राउत बनवाली राउत एवं कान्हार नाम उल्लेख थिला जहाँ सेमाने मिसिकी मारिचंती बोली लेखा थिला तापरे धनीराम गोटे मीटिंग डाकिथिले जोउथिरे बिहारी साहू मध्य उपस्थित थिले एवं घटना विषय रे चर्चा होइतिला चिठी पाइबा परे ताकू आनी आम अभियोग देला परे थाना रे पुलिस तदंत आरंभ करी अभियुक्त मानकु गिरफ्त कले तापरे सोनू साहू एडिशनल तहसीलदार को सामना रे निज दोष स्वीकार कला जे से एवं तार सांग माने बसंत विजय अन्य बनवाली और अन्य कान्हा सहायता हितेश्वर को मारिचंती से दोष स्वीकार करने समय मु एवं बिहारी साहू उपस्थित थिलु जहाँकि वीडियो रेकर्डिंग होई अछि सेठारे घटनास्थल को जाई सब कुछ देखाई पारि बोली से कहिला तापर ता सहित पुलिस साइंटिफिक ऑफिसर्स डॉक्टर मध्य जाइतिले केरा सागर अंटरे से झील को डाकिला एवं गर्भपात करिया पई औषध देवी बोली कहिला तापर झील सेटा को पहुंचिया परे सोनू झील को प्लास्टिक रस्सी रे तंटी को चुपिला विजय सबर गोड़ को धइला
this is in that confessional statement of that co-accused that I have done like this.
Yes.
Okay.
Additional Tahsildar, not police.
Right. Tahsildar.
Yes.
Anything else against this petitioner?
No, Miller. That's only confession.
What about criminal antecedent?
No CML.
Or the learned counsel for the appellant.
Yes. Submit for 1 minute.
Yes.
I was discussing with the concerned I over phone on this issue. He was telling that there are some CDR connecting this petitioner with the occurrence. At the time of occurrence also they had a talk. That is also there. That
or the learned counsel for the appellant, learned counsel for the state, learned counsel for the informant. The learned counsel for the appellant submitted that the appellant is in judicial custody since 8/11/2022 and he has been charge sheeted under section 364, 302, 201, 120B of the Indian Penal Code and section 321 bracket rakhibe B next bracket BA of the SC/ST PO Act. The deceased Hiteshwari Naik was found missing from her house since 6/1/2022, for which a report was lodged by her father, Dhaniram Naik, on 9/1/2022 before the inspector in charge of Nuapada police station. Though the case was registered and investigation commenced, but the whereabouts of the deceased could not be traced out. Ultimately, a skeleton was recovered from a field in the month of November 2022, and it was identified to be that of the deceased Hiteshwari Nayak, and the postmortem was conducted, and it was found to be a case of manual strangulation. The learned counsel for the appellant submitted that there are no direct evidence against the petitioner, and the only material available against the appellant is the confessional statement of co-accused Paramananda alias S.K.SAHOO before police. And it is the prosecution case that the said co-accused was having love affair with the deceased, and he made her pregnant, and then the deceased was killed. The Land Council further submits that though in the confessional statement of the co-accused it appears that there was criminal conspiracy between the said co-accused, the appellant, and others, but there is no clinching material to that effect. And in view of the available materials on record, the bail application of the appellant may be favorably considered. Learned counsel for the state, while not disputing that it is a case of circumstantial evidence, placed the 164 CRPC statement of witness Gajendra. कौन था नाटा पढ़ले गजेंद्र
हरिजन
हरिजन अच्छा गजेंद्र हरिजन, from which it appears that the co-accused Paramananda alias S.K.SAHOO made confessional statement before Tahsildar and admitted to have killed the deceased. The Learned Counsel for the state submitted that there is no criminal antecedent against the appellant. Learned Counsel for the informant submitted that he has received instruction that some CDR has been seized during course of investigation. Considering the submission made by the Land Counsel for the respective parties, the nature of accusation against the petitioner, since there is no direct evidence in the case, the nature of circumstantial evidence on record, and in the main circumstance is the confessional statement of co-accused, and the petitioner is having no criminal antecedent and is further taking into account his period of detention of the petitioner in judicial custody, I am inclined to release the petitioner on bail. It shall appear before the London Trial Court on each date when the case would be posted for trial, shall not indulge in any criminal activities or tamper with the evidence. Violation of any terms and conditions shall entail cancellation of bail. Allowed.
May pardon, my lord. Item 325, 25, my lord. Item 25, co-accused is similar to it.
25.
Yes, ma'am.
Yes, sir. 25 same.
Yes, ma'am.
Okay, allowed.
Lordship, may I submit, Lordship?
Yeah.
In fact, the occurrence date is 3rd of January. Inherently, it is written on 6th of January in the FIR, Lordship. That is the mistake.
But in item 25, notice has not been served.
Yes.
Notice has not been served in item 25.
Okay. Then you scroll down. Item 20, 26, no, 25.
25, ma'am.
25 notice is to be issued. Extra copy. You have been served with extra copy?
No,
it is coming for the first time.
It has come.
Oh, first time. Should be fair to the court.
Sorry, my lord, in front after.
No, I have no.
He may not engage him.
Yes, ma'am.
Well, 26 also.
issue notice, extra copy to be served. Usual order baki rest.
Well, 26 also same notice has to go.
Same matter.
Same.
All right. Issue notice. Extra copy. Yes.
Lordship, in the item 23, the date of occurrence may kindly be changed, Lordship. That was 3rd of January instead of 6th of January.
अच्छा सेटा जो but in the
हाँ FIR से भूल लिखिଛନ୍ତି subsequent statement से 3-1 लिखिଛନ୍ତି by the informant.
सेटा को जो 6 कहले ना सेटा को 3 कर
3-1 दिया
3-1 2022 है ना keep it with
23 22 is.
Yes, item number, next item.
Item 24.
What about 23?
23. Item 23.
Yes, Mr. Panda. Bail matter. Notice issued.
Yes.
No extra copy served.
Lordship, prefer next week.
No, 5D means state copy. Has it been served on you, Mr. Tripathi?
Yes, madam. Appeal memo served, but no extra copy not served.
The informant, sorry, opposite party number 2 also appeared, Lordship.
Faridi,
His
name is not appearing.
Mr. S.R. Das, Soumya Ranjan Das. Today he called me.
Soumya Ranjan Das.
Lordship.
Yeah, has he filed the wakalatnama?
Lordship.
All right, it's submitted by the Learning Council for the appellant that he has received instruction that Mr. Soumya Ranjan Das, advocate, has entered appearance for the respondent number 2 and filed wakalatnama. Let the register.
I'll serve the copy today.
Let a copy of the appeal memo along with all the annexures be served on Mr. Das during course of the day, and the registry shall verify and place on record the wakalatnama, if any, filed by Mr. Das. You have received the case diary?
No, Miller.
The Learning Council for the state submits that is yet to receive the case diary as well as the instruction about the criminal antecedent matter. I am keeping it on 7th.
Yes, Miller.
Okay, place this matter on 7th August 2023.
Placed.
Item 26.
Same as 22 and 25, Your Lordship mentioned. Notice as to 360 notice to 22 टा आपण allow कले 25 टा रखिले
25 26 पर गला
आज्ञा
Item 27.
SC/ST Act is there.
Press matter.
Press matter.
Okay, same order.
Item 33.
What is this BL appeal? Recalling of the order dated 27/11/2017. What order was passed on 27/11/2017? Passed by whom? JP Das already. So and so, the petition is an accused. It is alleged that due to some dispute for position of query, two persons were brutally assaulted and died at the spot. Earlier to some quarrel and tussle within the party. So Miss answer for recalling the order. First file this application. Look on Miss case number 1350 of 2017. This is an application for recalling the order dated 27/1/2017. None appears for the petitioner on 7/8/2018 when the matter was called. Nobody appeared. 2/7/2018 पर किसी ऑर्डर नहीं फाइल टी देखते बसगले कौन हम 7/8/2018 लास्ट ऑर्डर ना किसी ऑर्डर है Okay. This case stands dismissed for non-prosecution. Then same second one 5818 out of case page 1357. Same to dismissed for non-prosecution. Then another bill application is there. BLAPL number so and so. Report not received so and so. Miss case for recalling the order. As you recalling the order 1349 of 2007. Dismissed for non-prosecution. Yes.
Item 34.
Mr. Raghunath Biswa. CD available?
My lord.
Pass over.
Item 35.
Please, my lord, item 35, my lord, prisoner petitioner is there, my lord. In name of Sudhanshu Shekhar Das.
Prisoner's petition. आधे तो किसी लिखा ही नहीं कॉस्ट टाइटल या हमर लिस्ट रे आप देखले प्रिजनर्स पिटिशन कोन अछि कि
जेल फोन
जेल फोन कला जे अछि कि नहीं अच्छी किछि प्रिजनर्स पिटिशन ये एडवोकेट चेंज करियो दियंती हो एत कोर्ट रो कोन बुझी पर ना दी प्रिजनर्स पिटिशन अछि कि नहीं पचार जे आपण देयर इज नो सच पिटिशन so you huh you contact your client
my lord next
on the learning council for the what is your good name
Vikas Karna, my lord.
Mr. Vikas Karna learning council submits that he has received instruction that one prisoner's petition has been sent for engaging kahavu
Sudhanshu Shekhar Das.
Sudhanshu Shekhar Das
My lord, Bhinama.
no Bhinama you can file provided that you if you have obtained the consent or no objection matter is there is no necessity of again calling for that but if the consent is not there then on the basis of prisoner's petition one can be engaged as the advocate. So that wakalatnama contains the no objection from Mr. Chan or any of his associate. So that Sudhanshu Shekhar Das has to appear for him. कौन लिख ले author पढ़ ले कर्ण Stop. Let the registry verify the same and place it on record. Prisoner's petition. Okay.
Okay.
Item 36.
May please, Your Manners.
Pursuant to the order dated so and so affidavit. Affidavit. What type of affidavit? What is that affidavit?
Affidavit, my lord, some criminal cases were instituted against the present petitioner, and last occasion lordship directed to status of the case, my lord, this case, my lords, and trial has not commenced, my lords. And
no, have you served a copy on
my lord, sir?
Yes,
sir.
Yes.
The lower court has filed the affidavit and sent to me, and
it's a case under section.
Initially, FIR was registered for commission of offence under section 394 and 397 of IPC, my lords.
Yes.
And charge sheet was submitted offence under section 395 of IPC, my lords. And in this case, my lord, petitioner remanded on 22/11/2021, my lords. And only basing upon the confession of the co-accused statement, petitioner has been implicated. There is absolute no material, nothing, my lord. Only confession of the co-accused statement. That is the only material against the present petitioner, my lords.
There are some.
गोटे केस रो आगे अरेस्ट करी रिमांड लगेछन मेलो
सब गुडाको जोडाको अछि सब 395
yes madam
गोटे केस रो आगे रिमांड लगे मेलो देयर इज सब केस रो आगे रिमांड केवल देयर इज नो एब्सोल्यूट नो मैटर नथिंग मेलर्स ओनली बेसिंग अपॉन द कन्फेशन ऑफ द co-accused पिटिशन हैज बीन इम्प्लिकेटेड मेलर्स इन दिस केस मेलर पिटिशन इज इन कस्टडी मेलर रिमांड डेट होची 22/11/2021 मेलर्स सब केस रिमांड लगे मेलर्स
Is it correct that except the confessional statement of co-accused, there is nothing
My lord,
against?
he was remanded in this case. And based on confessional statement of
No,
co-accused.
thereafter you could have placed him in TI parade.
No,
He said that has not been done.
That has not been done. And also his confession statement is there.
Heard the learned counsel for the petition, learned counsel for the state.
And he is also having 4 criminal antecedents, my lord.
Learned counsel
same
for
nature.
the petitioner has filed the affidavit. As for the order dated 24/2/2023, which is taken on record. Considering the submission made by the learned counsel for the petitioner, that the petitioner was taken on remand in this case on 22/11/2021, and he has been charge sheeted under section 395 of the Indian Penal Code, and only material available against him is the confessional statement of co-accused before police, which is not disputed by the learned counsel for the state, and however, the learned counsel for the state opposed the prayer for bail on the ground of availability of 4 criminal antecedents against the petitioner. After hearing the learned counsel for the respective parties, nature of accusation against the petitioner, since the only material available against the petitioner is the confessional statement of the co-accused, and he was not placed in the test identification parade. After going through the affidavit filed in court today, I am inclined to release the petitioner on bail allowed.
Item 37.
Yes, Mr. Panda. Not there. So, CDH?
CD is there. Lordship on the last occasion had directed to verify its address of the accused, my lord.
Right.
It has partly complied because she was residing when he was arrested from Delhi, my lord. From Delhi, it was ascertained from the concerned police station that the house he was residing, that has been taken care. That was a rented house, and the articles has been taken away by the family members of the accused after her arrest. And from Manipur, where the native village of the accused, my lord, it has not been received by the IO, and he has paid for 1 week time for the same. For complying.
Item 37 pass over it.
No, he is yet to receive the instruction letter. The learned counsel for the state seeks 1 week time to obtain instruction regarding verification of the address of the petitioner as per the previous order. List this matter in the week commencing from 7th of August 2020. 7 तारीख दिन आशो करी.
Item 38.
It's a case under section 20B2C, Millard, and though there is huge quantity of ganja, Millard, but here, Millard, the petitioner was not arrested from the spot, Millard. Here, so far as the dates are concerned, Millard, on 7/5/2022, FIR lodged, Millard, and thereafter, after 5 months, on 18/10/2022, the petitioner was arrested, and thereafter on 27/10, charge sheet has been filed against him, Millard. And the so far as the allegations.
No, in the FIR, your name is there?
Name is there, Millard.
How it came?
Allegation, I am just coming, Millard. The allegation is that on getting information about hoarding of the ganja and that the petitioner hoard ganja in his house and ready to transfer the same to Millard outside Millard. And on getting that information, the police went to his house. And it is not a case that on seeing the police, the petitioner fled away or anything, Millard. They found on their arrival, petitioner was not there in the house, Millard. And thereafter, they seized 151 kg of ganja from his house. This is the allegation. And so far as Millard in the last order.
So, It's all right. You were arrested at a later point of time, but the ganja was seized from your house.
House, my lord.
So,
But the house, the place where the ganja was seized, that was a government land, and that was belonged to a millard reserve for the millard, and that order was there. There was an order to obtain instruction about that millard, whether the said land is government land or not, and that was reserved for millard.
Government land sangre kichi nahi. Government land re apon nei rakhibe. That becomes your possession.
That is the report of RI, my lord.
My
The RI's
house
report. That is the during investigation. RI was directed to conduct an inquiry, my lord. He submitted the inquiry report where it says, my lord, there is no movable or immovable property in his name, petitioner's name, in which house he is staying. That is belongs to government land. Under that is the description given. He has given
Government land re rakhithala au kon
No, millard. Here I have the RORs of the both the millard lands. I have my land is in my father's name, millard, and that is khata number 92, and the ganja
ବାପା କଣ ଆପଣଙ୍କର ବଞ୍ଚିଛନ୍ତି?
ବଞ୍ଚି ନାହାନ୍ତି.
ବଞ୍ଚି ନାହାନ୍ତି ଆଉ ଆପଣ ତ ଅଛନ୍ତି ତାର possession. In this type of case, it is to be seen who is in possession. Suppose somebody has taken rent of a house. House owner might not be knowing that what the tenant has kept in the house. So suppose the tenant is keeping ganja, he used to be responsible, liable, not that the owner if he is staying somewhere at another place.
That is not that house, millard. Amina Digal, the father of the petitioner, millard,
and counsel for
is
the
khata
petition
number 92.
Case of commercial quantity of ganja in view of the bar under section 37, not inclined to release the petitioner, trial be expedited and concluded within 6 months from the date of framing of the charge. Yes.
And another thing, millard, 25 is not there in the charge.
Yes, next.
Item 39.
No, item 39, after availing interim bail, in time surrender court bill, I given surrender certificate.
Surrender certificate dile. The land counsel for the appellant has filed, petitioner has filed the surrender certificate, which is taken on that. Yes.
Prefer adjournment.
You want adjournment? Yeah. The land counsel for the petitioner seeks for an adjournment. You have received the case diary?
Yes, madam.
All right. List this matter in the week commencing from 14th August 2023.
Item 40.
Yes, Mr. Patnaik.
Lordship, Lordship, in the meanwhile, charge sheet as a final PR has already been submitted. So, Lordship, 1 week time may be required, Lordship, to collect the same.
The land counsel for the petitioner submitted that he has received instruction that charge sheet has already been submitted and he intends to obtain the same. And the matter may be taken up on some other day. List this matter in the week commencing from 14th August 2023.
Grateful.
You have received the case diary?
No, my lord. I will.
Land counsel for the state also submit that he has not received the case diary, and let him obtain the case diary in the meantime, along with the criminal antecedent, if any, against the appellant, a petitioner.
Grateful.
Yes.
Item 41.
I'm not well today.
You are not well. You want it tomorrow or next week?
Next, after 1 week.
After 1 week. CD available?
Yes, my lord. Case data.
CD available and counsel for the petitioner seeks for an adjournment 21st August 2023. All right.
Item 42.
May I please the Lordship adjourn for 2 weeks.
CD available?
Yes, madam. CD.
All right, same order. 21/8/2020.
Item 43.
May I please? As your Lordship's direction, last occasion, the IIC of the concerned PS appear before through the VC, my lord, and orally submit that address verification is correct, and your Lordship direct to produce the written, my lord.
Yes, have you got that letter?
My lord. It is.
No, it should be a part of the court
Just
record. The Land and Council for the state produced the letter of the letter. Who has written it?
Letter of IIC Baripada Town Police Station.
Letter of the inspector in charge of Baripada Town Police Station dated.
Dated, my lord, that is 16 July 2023.
16 July 2023, which is taken on record. The লেখা আছে address verification found to be correct.
Yes, my lord. Address verification, he has received the instruction from Komna Police Station of Madhya Pradesh.
It is mentioned herein that the after the address verification of the petitioner was made, and it was found that the address furnished in the cause title was correct. Yes. Now you can argue the matter.
Custody, my lord, 24/11/22, my lord.
Yes.
Charge sheet, my lord, 23/3/23. Under section.
Yes, charge sheet under section
450.
450.
394.
Yes.
341.
Yes.
323. 307 IPC. Read with my 25 and 27 and submit. As for allegation, my lord.
Is it your first application? Is it the first application?
Yes, my lord. So is the transfer bill? So, my lord, I have no petition. Is the FIR and charge sheet with me, my lord. So, my lord, as for FIR allegation, my lord, the unknown person, my lord, entered into the house of the informant. May kindly see my FIR is. In the meantime, one unknown person jumped from the balcony of the house on and assault me and run towards the back side of the police station. Arrival of police.
Just a minute.
Yes,
all right, you just come to page 14, rejection order. Page 14, come to page 14.
Sorry, my lord, transfer bill, so application copy is not with.
What do you want now?
No, my lord.
Unless you have all these documents, how will you place the bail matter?
Present.
You are having only what?
FIR and final.
You are not having the bail application copy, even the rejection order, nothing is there. So, Mr. Mahapatra, please help him. Xerox karikin taku dei diyantu. The Land and Council for the. What is your good name?
KC Behera, Kedar Chandra Behera.
Your name is not there in the cause list. This is item number 44, na? 43.
43.
Oh, 43. Okay. Address verification da jo likhi dira tha upare. तापर लिखिए Mr. K.C. Behera, Land Council for the petitioner submits that since it's a transfer bill, he is not having the copy of the bail application, so also the rejection order. Let the Land Council for the state supply the same to the Land Council for the petitioner. Now, Xerox karikin taku yes.
Item 44.
May I please, Lordship? The petitioner is an unmarried gal male. She is in custody being charge sheeted under section 408, 467, 468, 471, 109, 120B of IPC, my lord. and she is in custody since 29/4/22, my lord.
Come to the order dated 4/7/23.
Yes, my lord.
Learned counsel for the petitioner during course of argument submitted that
Authorized-
even though a sum of rupees 97,53,900 came to the account of the petitioner as per charge sheet, but substantial amount has been transferred to the account of the co-accused Vikas Kumar
Vikas Kumar,
from the account of the petitioner, and the said co-accused has already been released on bail. When a query was made to the learned counsel for the state as to how much amount has been credited to the account of Vikas Kumar
my lord,
from the
7 lakh.
account of the petitioner, and what are the amount available in the account of Vikas Kumar when it was freezed, he seeks some time to obtain instruction from the investigating officer. Okay, and whether you are ready and willing to deposit the misappropriated amount. All right. So, what is your instruction?
My lord, the instruction is the Vikas Kumar was arrested, and it was instruction received from the IAC, my lord. No money was recovered from Vikas Kumar.
Oh, no money.
Allegation is that, my lord, petitioner was the accountant in Centurion University. He was receiving the tuition fees from the students
Right,
on
right.
behalf of the.
No, what he says made a submission that the amount, some substantial amount, has been transferred to the account of
That
Vikas.
has not been recovered. Well,
That is
specific-
not there. No, no. Whether it is a correct statement or not, that
No, that is not correct statement.
then how
My lord, already transferred, my lord, as it reveals from the investigation.
During course of investigation, there is a statement he has transferred the money to the
Yes,
account
yes.
of Vikas
That
Kumar.
was verified and found
Yes,
not
my
to be
lord, that
correct.
has been verified. He clearly states no money has been.
All right, look on. The learned counsel for the state has obtained instruction as per order dated 4/7/2023 to the effect that no money has been transferred from the account of the petitioner to the account of the co-accused Vikas Kumar. ଆଉ କଣ ଚାହୁଁଛନ୍ତି?
ସେ ଲେଖୁଛନ୍ତି ଫୋନ ପେ ଗୁଗଲ ପେ ରେ ଡିପୋଜିଟ୍ ହେଇଛି ବୋଲି ଆଜ ପର ଇନଭେଷ୍ଟିଗେସନ।
ଡକୁମେଣ୍ଟ ଆସିଲା କିଛି ନାହିଁ, ହେଇନି। ଆପଣ କଣ କରୁଛନ୍ତି ମୁଁ ଜାଣିନି। ବର୍ତ୍ତମାନ ନେକ୍ସଟ କ୍ୱେଶ୍ଚିନ୍ ହଉଛି whether you are ready and willing to deposit the students' money or not.
And he is filing
My lord,
only for payment of rupees 1 lakh, depositing of
father
rupees
is-
1 lakh, my lord, against the misappropriation of rupees 97 lakhs. Yes, my lord.
Lordship, father is details of holding in the village, my lord.
ସେ ଟଙ୍କା ଆପଣ ରଖିଲେ, ଟଙ୍କା ଷ୍ଟୁଡେଣ୍ଟ ମାନଙ୍କୁ ରଖିଲେ, ଆସ୍ୟୁରାନ୍ସ ଦେଲେ, ଆପଣ ଏଠି ଗୋଟେ ଷ୍ଟେଟମେଣ୍ଟ ଦଉଛନ୍ତି ଟଙ୍କା ଅନ୍ୟ ଜଣଙ୍କ ଆକାଉଣ୍ଟ ମୁଁ ପଠେଇ ଦେଇଛି, ତା ଆକାଉଣ୍ଟ କୁ କିଛି ଯାଇନି।
ନାଇଁ ଯାଇଛି,
କଣ ଆପଣ ଯାଇଛନ୍ତି? ଇନଭେଷ୍ଟିଗେସନ ତ ରିଭିଲ୍ କରୁନି କିଛି। ଆଉ
ଲର୍ଡସିପ କାଇଣ୍ଡଲି
that ମୁଁ ଏଠି କଣ ଭେରିଫାଇ କରିବି ନା କଣ?
ତାଙ୍କ ରେକର୍ଡରେ ବି ଅଛି ଏଟା।
Now whether you are ready and willing to pay this amount, if not,
ଜଣ ନାଁରେ ଚାର୍ଜସିଟ୍ ହେଇନି, 10 ଜଣ ନାଁରେ ଚାର୍ଜସିଟ୍।
ଏ କଣ ଥିବ କି? Question is ହଉଛି, is a question of economic offense. You have cheated the none else than the students, and
এটা ବିକାଶ କୁମାରଙ୍କ ଆକାଉଣ୍ଟକୁ ଯାଇଛି ବାଇ ଫୋନ ପେ ଆଣ୍ଡ ଗୁଗଲ ପେ ବୋଲି ଲେଖିଛନ୍ତି ସାର୍, ଇନଭେଷ୍ଟିଗେସନ ବି ଅଛି।
forget about that. That instruction has already been taken. That nothing was there. Whatever you received instruction, that is from your client. Now he has received the instruction from the IO on the basis of the documentary evidence collected, on the basis of the order passed by this court. Your client may say that I have not taken anything from my account. Everything has been transferred to the account of X, but they did not find anything. If the accounts were verified and it was found nothing was transferred. So if it has not been transferred, so if you have either it is with you or you might have transferred it to some other account of some other person. We are not concerned about that. We are concerned about that whether you are ready and willing to deposit that amount or not.
Father has filed an affidavit, my lord. Only he is willing to deposit rupees 1 lakh.
देखिए ना से ऊपर लाइन था The learned counsel for the petitioner has filed an affidavit of the father of the petitioner, wherein it is mentioned that his financial condition is very, very poor, and he is ready and willing to deposit a sum of rupees 1 lakh out of the misappropriated as alleged by the informant. The affidavit is taken on record. The prosecution case is that the petitioner was working as office assistant in the accounts department of C.V. Raman Global University, Khurda, and he was assigned the job of collecting tuition and hostel fees from the student. It is the case of the prosecution that on verification it was found that the petitioner has committed criminal breach of trust as office assistant of the university and collected tuition and other fees of rupees 97,53,900 and has not deposited the same in the account of the university, thereby misappropriated the same for his own use. The State Court Council submission lecture and you verification level. Like this, considering the submission made by the land council for the respective parties, the manner in which the students have been cheated and the amount involved in the case, at this stage I am not inclined to release the petitioner on bail. The petitioner is at liberty to renew the prayer for bail after examination of the material witnesses in the trial court. The trial court shall do well to expedite the trial.
Lordship directed to expedite the trial.
Expedite trial kali material witness hela pare renew karibe taku bhi kali hala. All right, next.
Item 45.
Mr. D.P. Dor.
The file has been transferred from us.
ये जो लिस्ट रे कज लिस्ट रे जो ना आछि सब आपन का एसोसिएट
नहीं नहीं खाली डीपी जन थे प्रफुल्ल चंद्र आचार्य आज्ञा हमर फाइल हैज बीन ट्रांसफर्ड
ट्रांसपोर्ट कोन आपन को चेंबर जाई
मिस्टर प्रफुल्ल चंद्र आचार्य एडवोकेट फाइल वकारनाथ नामा फॉर लीगल हेयर्स ऑफ द डिसीज्ड
All right, since Mr. Prafulla Chandra Acharya has filed Wakalatnama for the legal heirs of the deceased appellant number 3. You are for the other appellants. And is not appearing to move the interim application. This matter in the week commencing from 21st August 2023. I'm phone kari tie kahi diyantu se criminal appeal conviction ହେଇଥିବ ନା ସେ ମରିଗଲାଣି ମାନେ legal heir substitute ନହେଲେ ଗଲା ତା ସେ matter ଟା ଗଲା abate କରିଯିବ କିଛି ରିଲିଫ ପାଇବେନି ଯଦି କଣ କୋଉଠି ଦରମା ହେରିକା ହେଲ୍ଡ ଅପ୍ ହେଇଥିବ ଗଲା। Next.
Item 46.
46, your lordship, I have filed an IA for early hearing of the case, your lordship.
This case for appropriate order. So where is Mr. Sanjay Das?
I am present, my lords.
So you are there.
May it please.
It is a 2014 appeal. So this case is 477 of 2017. This is for early hearing.
No, the second one is there. Sub item is there.
So, acha, 155.
1559 of 23.
ठीक है 1559. कहीं से फाइल नहीं 1459 कहीं ଅଛି କି ଦେଖିଲୁ ଦିଅ କଣ ତମେ ଅଧା ଇଏ କରୁଛ ଅଧା କରୁନ ସ୍କାନିଂ ହଁ 1559 ନାହିଁ ତ ହଁ ସେଇ ଆଇଏଟା ମୁଁ ଖୋଜୁଛି ପୁରା ଏଥିରେ ଅଛି ଯେ ମୁଁ କହିଲି ସ୍କାନିଂ ହେଇନି ଲାକ୍ସି ଆରେ ବାବୁ ଆଧିରେ ନାହିଁ ପରା କହୁଛି କଣ ବେ ବୁଝିପାରୁନି କି এটা କରିକିନି ସ୍କାନିଂ କରି ତା ଦେହରେ ଲଗେଇବ Are you interested to prepare the paper book because the paper book has not been prepared?
So I have deposited the cost. Office may directed to prepare the paperwork, your lordship.
Serially kari କରୁଛନ୍ତି Why don't you apply for the certified copy of those evidence and file it by preparing a paper book? All right. The IA number 1559 of 2023. This is an application for early hearing of the appeal. Learn counsel for the this appeal is tagged to this is a separate case, na?
Separate case. That is for confiscation. Your CRLA.
Acha.
217 of 2014.
Now you are placing this 549 of 2013.
Yes.
The second account. Is ready and willing to deposit the cost of the paper book, and the office may be directed to prepare the same. Mr. M.S. Rijvil and counsel, additional standing counsel for the Vigilance Department, has no objection to such interim application. Considering the submission made by the land counsel for the respective party, the office is directed to prepare the paper books at earliest, since it's an appeal of the year 2013, and the cost for preparation of the paper book shall be assessed, and the appellant shall deposit the same within 1 week after the cost is assessed. List this matter immediately after the paper books are prepared. तापरे hearing date fix up होगा. Yeah.
If my name may be reflected in the cause listing.
The name of Mr. M.S. Rijvi be reflected in the cause list in place of Mr. Sanjay Kumar Das. Right?
Grateful.
Item 47.
May I please notes. I have filed a IN number 1570 of 23, my lord, for a expeditious hearing and a preparation of paper book, my lord. In the case of 2014, my lord, the vigilance case, my lord, the petitioner is an
What
old
is it?
man, aged about 70 years, my lord, suffering from different
Offense
old
con,
age
offense
disease.
con, trap case na.
My lord,
Trap case na disproportionate asset na misappropriation con.
misappropriation, government road.
Okay. IA number so and so is an application for expeditious hearing of the appeal. It seems that paper book has not been prepared. Then see you go na the submission college, he is ready and willing to bear the cost for preparation of the paper book. Let the cost be assessed and deposit be made within 1 week thereafter. Matter listed, never date the IA will be considered after preparation of the paper book.
Here also my name may kindly be reflected in the cause list.
The name of Mr. M.S. Rijvi be reflected in the cause list henceforth in place of Mr. Sanjay Kumar Das.
Grateful.
Item 48.
Item 48, my lord, I am filing the Vakalatnama again because I have been requested to appear in this case by virtue of the presentation and Vakalatnama has been sent.
Prisoner's petition at flag L, praying for engagement, Asha. Period the prisoner's petition at flag L, in which prayer has been made for engagement of Mr. Dipti Ranjan Mahapatra, advocate, in place of the Mr. Nityananda Panda. You have filed your Vakalatnama?
Yes, I am filing.
Mr. Mahapatra has filed Vakalatnama in today, which is
in this case, I was the advocate. The brief was transferred again, it is returned to me.
All right.
My lord, here in this case, pursuant to lordship's discussion and favorable order has been passed for interim bail. He was released on interim bail and has been surrendered in due course. He surrendered and that's why your lordship by the order dated 3rd of July directed for calling for a report from the London court below.
What is the order dated?
3/7/2023. Because
it appears that the appellant has been granted interim bail for a period of 3 months as per order dated so and so. And Land Counsel for the appellant was asked to produce the surrender since no surrender certificate. Let a report be called from so and so, whether availed or not. What is that report?
But my instruction he surrendered on 27th.
Report aschi ki trial court ru dekho. Status report magai dila.
Flag mark ta dekhna. Last.
No, report is not there. Not received.
Then. On L data or prisoner's petition?
No report. There is nothing, my lord, in the cause list. No report has been received from the.
But by instruction, he surrendered on 27th of June.
ସେଇଥିପାଇଁ ଆପଣଙ୍କର ସବମିଶନ ତାକୁ ଜଷ୍ଟିଫାଏ କରିବାକୁ ଯେହେତୁ ଆପଣ କୌଣସି ସରେଣ୍ଡର ସାର୍ଟିଫିକେଟ ପ୍ରଡ୍ୟୁସ ନ କଲେ
ତାଙ୍କର ପ୍ରିଭିୟସ୍ କାଉନସିଲ କେ
ସେଥିପାଇଁ ଆପଣଙ୍କୁ ଅପେକ୍ଷା କରିବାକୁ ପଡିବ
my lord. And in addition to that, I am filing one interim application today. May I please lordship call this matter next week?
Is taken on record. The name of the newly engaged counsel shall be reflected in the cause distance board. The name of the earlier engaged counsel shall not be reflected. The in spite of the order dated 3/7/2023, no report has been received from the learned additional session judge Jashpur the Learning Register Judicial shall send reminder to the concerned court to submit the report. Put of this matter, give a date. Yeah.
May I play week commencing 7th because I am filing one IA today. Because the health condition of his wife and 50% ଗୋଟେ ଗୋଡ଼ ତାର କଟା ହେଇଯାଇଛି.
Mahapatra, unless I know, I have the proof that you have surrendered.
I am trying to produce the certified copy on the next day.
That will be done. Even the report doesn't come, that doesn't matter. Once you produce something that you have surrendered, I want that, and you are not producing.
My lord, may call this matter on 7th of August, so that on that date I will also produce the certificate.
On 7th of August.
I am grateful, Lord.
Item 49.
I mean, pardon my lord, item 45 ଟିକେ ଡେରି ହେଇଗଲା.
45,
my lord, 45. I am pardon my lord.
45 has been kept to another date.
Passed over.
That is on 21/8/2023. That that will come on that day. Yes, next.
मैंने tomorrow कर दियो.
Order has already been passed. Yes, next.
Item 49.
49 paper after 2 weeks file the impu order, my lord. Order dated 29/2/2015, my lord.
You want adjournment?
Paper
What time?
2 weeks.
What is this CRLA for?
Under section challenge the under section 446 CRPC against the Baylor proceeding against the Baylor, my lord. Perpetrating the bailment and surety and impose 50,000 cost and a civil imprisonment under 30 days against the Baylor.
Sure. So it's a 2016 appeal.
Yes, ma'am.
And you have not filed the impugned order itself.
This is report.
Why it will be entertained? If in spite of passage of 7 years from the date of filing, you are unable to file the impugned order, then
last chance.
No, last chance. It is not that today this matter is coming. Earlier also you are granted time for the said purpose.
Already intimated.
SRB ହେଇନି ଏପର୍ଯ୍ୟନ୍ତ ଯେହେତୁ ଆପଣ impugned order ଟା ଫାଇଲ କରିନାହାନ୍ତି SRB ହେଇନି ତ ଗୋଟେ matter 2016 ରୁ ଆପଣଙ୍କର laches ଯୋଗୁ since you did not file the impugned order, it is pending.
Last chance.
No, it is already granted to you. It is 4 opportunity has been provided to you. Today I am passing the 5th order.
Last chance.
The
paper last chance.
Land Council for the what is the amount that was imposed on you?
50,000.
50,000. The Land Council for the petitioner, appellant. 1 week further time to file the certified copy of the impugned order dated 29/2/2016, passed by the Land CGM Rayagada. List this matter in the week commencing from 14th August 2023. It is made clear that no further adjournment shall be granted. Yes.
Item 50. Pass over item 34.
None appears on behalf of the petitioner. On repeated calls. When the matter was called on 2/5/2023 and then on 27/6/2023, no one appeared for the petitioner on repeated calls. The appeal application stand dismissed for non-prosecution. Yes.
Item
May I please, Miller?
Item number 53, my lord. Item number 53 may not be taken up next week, my lord. Because on the last occasion, lordship directed to take instruction whether the other co-accused persons have been arrested in the meantime or not. This is a case, my lord. Informant has come in this appeal, my lord. The petition under section 457 CRPC was filed to release the cash which was seized from the house of the present petitioner, my lord, who is the informant in the court below. And the learned trial court, my lord, refused the prayer on the ground that investigation is open in respect of other co-accused persons who have not yet been arrested and not faced the trial, man. So instruction was called for.
No. You see, it's a seizure of cash. So if it's the informant's money,
Yes, sir.
and suppose the accused persons are acquitted, and the direction should be given that it should be returned to those persons from whom it has been seized.
Right, man.
So
To the bona fide owner, that is true, man.
So suppose they are not arrested for years together. It's a it's not an identifiable property, money,
Yes,
rupees. So he has to take it and giving assurance that suppose results so he will deposit back that
Yes,
amount. Support, let us say somebody else would claim something on that property.
Fine.
So that's a so. What is your prayer in this one?
Prayer to release.
452 CRPC petition was rejected.
Yes, ma'am.
What is that impugned order?
Had impugned order. Impugned order dated 23/12/2016. Next page, madam. Last page, madam. No order is passed.
Yes, just a minute.
Last no order is passed regarding disposal of the seized cash and property since investigation of this case is open against other accused persons. Thus, it seems an order passed in the
ठीक है wrong. Page के देखो जनी.
Last page.
Judgment of last page.
Madam.
Convict Susama Barik is received the stolen cash of rupees also. In my opinion, sentences are to run concurrently. No order passed regarding disposal of the seized cash and properties in investigation of the case is open against other accused persons. Here they were sentenced to rigorous imprisonment for 7 years.
Madam.
So
Yes,
that means found to be
Guilty.
Yeah. What is your 452 petition?
457 petition I have last time filed, madam.
Have you given a copy to
Yes,
Mr.
ma'am. Yes, ma'am. I have also given a
Mr.
chat.
Mishra?
No,
452 petition, please come. He must have given to you.
No,
Agur date.
No, give another copy so that. Judgment रे किसी रखा गला जे नहीं वर्तमान किसी विचार होबनी. But you have stated in your 452 petition that during course of investigation, cash was recovered from the possession of the accused persons which were stolen from the house of the petitioner. And while that cash has been recovered during course of trial, alleged to have been recovered belong to the present petitioner and is the rightful owner of the cash for which he claimed thereof. In the meantime, judgment has been pronounced, so and so have been convicted. Statutory provision of the law, property has been looted and so entitled thereof. In some case, there is cogent and convincing evidence. Petitioner is the rightful owner of the cash. One करो. Which has been seized from the accused person, for which he is entitled In view of the fraction petition is entitled so and so. Okay. So, what order was passed on your 452 CRPC petition?
Petition was rejected. No order is passed regarding disposal of the seized cash and property.
No, ସେଇଟା ତ ହେଲା
ଆଜ୍ଞା।
ତାପରେ ପରେ ଆପଣ 452 ଦେଲେ ଜଜମେଣ୍ଟ ହେଲା ପରେ 452 ଦେଲେ ନା
ଏଇ petition ଜଜମେଣ୍ଟ ଏଇ petition ଟା ରିଜେକ୍ଟ ଜଜମେଣ୍ଟ ହେଲା ପରେ ଏଟା ଦେଇଥିଲେ 26/12 ଏଟା ରିଜେକ୍ଟ 23/16 order.
No, this 452 CRPC petition obviously was filed after the pronouncement of the judgment. So after you filed that 452 CRPC petition, whether any order was passed?
No order has been passed. That is mentioned. 23/12 petition, no order is passed.
Where you will get that?
Man, 23/12/2016 order.
23? अरे एटा आपण फाइल कले केबे की एपण 5/12/2016 रे कॉपी देइचंती एडिशनल पीपी को ए साइड रे लिखा हिची
आज्ञा
रिसीप्ट कॉपी
23/16 रे डिस्पोज ऑफ होइछ
हां
23/16 रे डिस्पोज ऑफ होइछ
23 रे ए पिटिशन दा
आज्ञा
से ऑर्डर टा काई
आज्ञा 23/16 ऑर्डर इन पढुतले इनपुट ऑर्डर 23/16 इनपुट फाइल लिछि हम अपील रे
ठीक है
23/16
okay this one acha says that since that order has already been passed in the while pronouncing the judgment, there is no scope to entertain such a petition.
It was the court lacks jurisdiction to review its order. According to the petition so filed by the petitioner, stands merit for acceptance and stands rejected.
His appeal has been filed under section 454 of the CRPC.
My lord.
So any citation you have brought?
My lord, citation.
Not on 457. এটা ঠিক আছে। এটা দেখলো 454
83 97 CLT 540
হুম
83 volume 83
হুম
97 CLT 540
1995 CLT page
83 97 CLT 540
what is the name of the party?
Srimati Tarini Mohapatra and Anandar versus State of Orissa.
I don't know. $452. Now let us come to the judgment in which they were convicted. That is at page. Oh, okay. Let us see that what is your case. You are the informant in that case.
Yes, ma'am.
You are the informant.
Yes, ma'am.
Informant and German as PW6.
PW6. So you are Pankaj Kumar Mahakur. Pass on your evidence copy.
Last time.
ଦେଇଥିଲେ?
ଆଜ୍ଞା ଦିଆହେଇଛି।
ଆଚ୍ଛା। Okay. In the paragraph number 2, page 3 of the judgment, where the prosecution case has been mentioned, the occurrence took place in his house. So, then he says about the cash, etc. It is mentioned. They took away the Scorpio, their mobile phones bearing numbers so and so, gold ring and cash of rupees 50,000 from Bulu Bari, cash of rupees 40,000 from Ramakanta Bari. So the total cash, according to you, which were stolen is 90,000. 50 from Bulu and 40 from Ramakanta. Then you mentioned the dacoit broke open the lock of the almirah, took the gold and silver ornaments of rupees worth so and so, and also ready cash of rupees 2 crores kept in the said almirah. Oh, I see.
Kept in the settle.
When the dacoits tried to flee away, at that time Pradeep Mahakur managed to escape. Okay, that was your case as per the FIR. Now let us come to the evidence.
And I may pardon. Pursuant my lord's direction, I have prepared a date chart. My lord has directed me. I have handed over to court master.
Yes, sir.
Page 1, Pankaj Mahakur. Complaint. Vehicle key, mobile number, money purse, gold ring, rupees 50,000 from pocket, rupees 40,000 from RAM, from Almira gold and silver about 35 to 40 dollars and cash of rupees 2 crores have been stolen. Statement the court, cash of rupees 50 column, cash of rupees 2.5 crores and gold ornaments about 40 to 45 varies. And kindly see page 3, the mother of the informant, P14. Stated that the accused persons entered into her room, asked her about valuables. Thereafter, the accused persons broke open the almirah and removed all her jewelry and took away cash of rupees 3 to 4 crores, which were kept in the said almirah.
This PW1 is the informant.
So, P6 is the
Huh?
P6 is the informant. P14 is the mother of the
P6 is the informant.
matter.
Then PW?
14, page 3, P14, mother of the informant.
Mother of the informant, okay. And what cash was recovered from the accused persons in the judgment? Is it there?
Judgment is not clear.
No, as per the seizure list, property seizure memo, what cash was seized? ଆପଣ ତ ଦେଇଛନ୍ତି ସେଟା ମାର୍କ ହେଇଛି ବୋଧେ property that is exit.
କୋଉ accused କୁ କଣ ଦେଇ ଲେଖିଛି?
No, this is marked as an exhibit or what?
Exhibit 9 ରେ କିଛି ଅଛି, exhibit 6 ରେ ଅଛି, exhibit 20 ରେ କିଛି ଅଛି. Page 5 and 6 of my chart. ଆଉ exhibit 1 ରେ 14 ରେ exhibit 4 ରେ.
Exhibit 4 ରେ ଲେଖା ହେଇଛି 9 ଗୋଟି 1000 ଟଙ୍କିଆ ବଣ୍ଡଲ, ପ୍ରତ୍ୟେକଟିରେ 100 ଟା ଲେଖା, ଅର୍ଥାତ୍ ମୋଟ ହେଲା 9 ଲକ୍ଷ. So this is ଲେଖିଛନ୍ତି ସେଟା ଆଦିରେ?
ନଅ ଲକ୍ଷ page 6, 7 ରେ ଲେଖି ଦେଇଛି. On 4th, he arrested the accused Rajesh Parikh on the basis of his confession. A cash of rupees 9 lakhs was recovered.
କୋଉଠି ଲେଖିଛନ୍ତି?
Page 7 of my chart.
7, ହଁ.
Deposition ଗୁଡା ଦେଖିକି
ନାଇଁ ଏଟା ହେଲା 9 lakhs ହେଲା କୋଉଥିରେ? Exhibit 4 ରେ. ତାପରେ
exhibit 14 ରେ 10 lakhs.
14 ଟା ଦେଖିଦବା ଟିକେ ରୁହ. This is exhibit 14. Exhibit 14 ଲେଖା ହେଇଛି ଗୋଟିଏ 1000 ଟଙ୍କିଆ ବଣ୍ଡଲ, 87 ଗୋଟି 1000 ଟଙ୍କିଆ ନୋଟ ଏବଂ 26 ଗୋଟି 500 ଟଙ୍କିଆ ନୋଟ ଥାଏ. ଏଇଟାରେ 87 ହେଲେ ହେଲା 87,000 ଟଙ୍କା, ଆଉ 26 ଗୁଣନ 500 ହେଲେ 13,500. 13,000 ହବ. So it is 1 lakh, right?
1 lakh.
So that is, sorry, it would be 10 lakhs ହଉଛି. 87,000 plus 13,000. 000. आपण पूरा 87 गोटी 1000 टंका 87 गोटी 1000 टंका हेले हेला 87,000 टंका
87,000
तापरे बाकी हेला 13,000 टंका
आज्ञा
26 टा 500 टंकिया
आज्ञा लक्ष्य हब
तो लक्ष्य बा 10 लक्ष्य कोन लिखछन
एटा लक्ष्य हब
रुपीज 1 लाख देन आउ गोटा कोन एग्जिबिट 1
एग्जीक्यूटिव 1
एग्जिबिट 1 लेखा होची 9 गोटी 1000 टंकिया प्रत्येक टिरे 100 गोटी थाई मोट एटा नहीं कि ए देलो से ट्रायल कोड रिकॉर्ड दल आनो এটা কোড পাইলে এক্সিবিট 1 টারে যে 8 লক্ষ 20 সেটা পড়ে আছে ডকুমেন্টটা নাই Where is the schedule list?
P2 17 evidence ରୁ କରିଛୁ
70
P2
schedule list ଆମେ
17
ଦେଖିବି ନା
evidence IO evidence
एग्जिबिट 1 केते लिखछन ता धरे 8 लक्ष 20
ଆଜ୍ଞା
गोटे पॉलिथिन ने 8 लक्ष 20 हजार टंका ए तीनटा सीजर लिस्ट
ନା ଆହୁରି ଅଛି ଆଜ୍ଞା ତା ପୂର୍ବରୁ ଆହୁରି ଏକ୍ଜିବିଟ୍ 6 ପେଜ 5 ରେ ଥରେ ଦେଖି ଦିଅନ୍ତୁ ଏକ୍ଜିବିଟ୍ 9 ରେ ଅଛି 60,000
पेज 7 pra कहले देखिली
ହଁ ପେଜ 7 ରେ ଅଛି ପେଜ 6 ରେ ଅଛି ପେଜ 6 ରେ ଆହୁରି ଏକ୍ଜିବିଟ୍ 6 ଆଉ 20 ଅଛି
8 ଲକ୍ଷ 20 ତାପରେ
ଏକ୍ଜିବିଟ୍ 6 ରେ 19 ଲକ୍ଷ ଏକ୍ଜିବିଟ୍ 20 ରେ 5 ଲକ୍ଷ
ଏଟା କୋड लिखछन
ପେଜ 6 ରେ
एग्जिबिट 6 ରୁ 19 ଲକ୍ଷ
ଆଜ୍ଞା
एग्जिबिट 20 होची 5 ଲକ୍ଷ
ଆଜ୍ଞା ଆଉ ତାପରେ ପେଜ 5 ରେ एग्जिट 9 रे 60,000 60,000
60,000
हाँ पेज 5 रे आगे
एती तो
आगे
यू डू वन थिंग ए जो एलसीआर रे
आगे
फ्लैग मार्क कर दियंतु से जो एग्जिबिट गुडा कागज गोटे दी देबे लिखि देबे एग्जिबिट काली एटा टेक अप करी मु हला
R2 पे
हां जहां भी हो से
आई रिक्वेस्ट मैडम
नो नो इट्स ऑल राइट बट फाइंड आउट नाउ जस्ट
मो सांगे मो स्टिकर मार दो छै
otherwise it's creating problem तो बाहर करिया एटा रखी था ए डिसीजन टा भी रख
मो सांगे स्टिकर रखसी मार दो
Yeah.
आगे
keep it
हेलो भुवनेश्वर विजिलेंस बेल আছে 11টা বেলको
no it's all right
দিটা বেলको
tomorrow man
Tomorrow at 2
at 2
p.m.
o'clock this is item number 53 will be taken up on 1/8 of 2 p.m. okay Yes.
Item 50.
Two 2019. No, their old appeals are pending.
2 weeks after as well.
Is this matter in the month of September 2023? ये जो आईए नंबर सो शो कर दो ना और जो अर्ली हियरिंग से गोटा कर देवे सितंबर as. Yes, next.
Item 57.
Item 57, I have filed an IA for condonation of
Criminal appeal conviction
against acquittal.
372 CRPC appeal. Informants appeal against
Yes.
acquittal. What are the offenses here?
307.
307.
Yes, sir.
They are acquitted of all the offenses or?
Yes, my lord.
So, what is the delay as pointed out? 87 days.
Yes, sir.
Notice has been issued.
Notice has been.
Huh?
Yes, sir.
Run counsel for appellants upper. Same address given in there.
Council has also appealed.
Who is appealing? Yes, somebody is Prashant Kumar Nanda. All right, IA number so and so. This is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 87 days in filing this criminal appeal. After considering the grounds taken in the interim application and hearing the land counsel for the non-appeals for the opposite party, number 2, land counsel for the petitioner, so also land counsel for the state. I am inclined to condone the delay. Accordingly, delay is condoned. the matter be placed for admission in the week commencing from 7th of August 2023.
Item 58.
Condoned 7
May
8 2023.
This matter the Opioid Act and the IF for the condolation of delay.
OPID Act conviction matter?
No, release of vehicle.
Release of vehicle. So,
Delay of.
what is the delay pointed out? Stamp reporting. Fine. देखो कैसे डिले है पेजटा पढ़ा कौन मन इच्छा करते सम्मान सब Who are the opposite parties here? IIC, so it's a state.
Yes, ma'am.
Have you given a copy to Mr. It's a OPID Act matter means Mr. Bhuiya and Mr. Patra has to do with this matter. Yes. Have you served a copy on Mr. any of them?
Well, I will serve the extra copy also.
Right. IA number 832 of 2019. This is an application for condonation of delay. Since this matter arises out of OPID Act proceeding, let the copy of the interim application be served on Mr. Vivekanand Bhuiya or Mr. J.P. Patra, London Special Counsel who used to appear for the state of Odisha in such matters. The name of the Mr. Bhuiya and Mr. Patra be reflected in the cause list. Out of this matter, you serve the copy during by tomorrow or day after tomorrow?
Day after tomorrow.
Okay, put up this matter on 7th of August 2023.
Okay.
Item 59.
59 matter pass over on behalf of Mr.
Surrender certificate.
Surrender certificate?
Yes, ma'am. Surrender certificate.
No, surrender certificate.
Yes. Okay. Yeah. Yes. I'm sorry, my lord.
What is this criminal appeal for?
Plus the against the conviction, my lord. Actually, this my lord, for amendment extreme, my lord, I can place.
20B2C?
Yes, my lord.
So you are released on interim bail for it?
3 months. 3 months. As philosophy direction, only 3 months, my lord.
You surrender at right time?
Yes, my lord. The order dated 5/4/2023 that was granted to me 3 months interim bail. Now, after completion of 3 months, my lord, then I have surrendered on 17/7/2023.
The learned counsel for the appellant has filed the surrender certificate with a memo which is taken on record. Yes. Next.
Call it next week, my lord. Call it next week.
For what purpose?
No, sir.
Yes.
The paperwork has not been ready.
Oh, that will come in normal course.
Item 60.
60.
Your lordship was pleased to grant interim bail for a period of 3 months, my lord.
Right, you have to produce the surrender certificate.
No, lord. I pray next date may be given. By that point of time, I will file it.
What is your instruction whether he has surrendered or not?
He has already surrendered. Only I will obtain the surrender certificate.
The learned counsel for the appellant submits that after availing interim bail period, as per the order dated so and so, the appellant has surrendered and he may be given some time to produce the surrender certificate. Are you taking this time for the first time or earlier you have taken?
First time, my lord. First time.
All right. So I am keeping it to 14th August.
My lord.
Release this matter on 14th August 2023. Land Counsel for the appellant shall produce the surrender certificate. Yes.
Obliged.
Item 61.
Mr. Roy, S.S. Roy, Suchit Kumar Naik, to produce the surrender certificate again. আচ্ছা এটা 500 করে করুন তো দেখি next
62.
May I please, your lordship? Lord, here the IA is for interim bail, your lordship, 141-155-2023. In the last occasion, your lordship asked the state to obtain instruction.
on what ground you are seeking for interim bail?
On the health ground of my wife, my.
Have you filed any medical
Yes,
document?
your lordship. And sir, one that your lordship.
So
asked the
what
state to
instruction you have received, Mr.
Yes, sir. The prescription is genuine and we recommended by the doctor to go for surgery operation.
Pass on that, or give a copy by through your mobile. Give a copy.
Yes, sir.
IA number 1415 of 2023. This is an application for it's a local man.
Yes, your lordship.
Yes, yes.
For interim bail on the ground of ailment of the wife of the petitioner. Medical document in support of the ailment has been annexed to the interim application. The Land Counsel for the state was asked to obtain instruction on the interim application. Today, the Land Counsel for the state has produced the letter dated so-and-so 12/7/2023 of Inspector in charge of
Inspector of Excise.
Inspector of Excise.
Striking Force Chhatrapur Ganjam.
Striking Force Chhatrapur Ganjam, wherein it is mentioned operative part padi diyantu.
We also visited the clinic of Dr. Vipit Nanda at Nachuni and verified the prescription to be genuine.
The document was verified and it was found to be genuine,
and Dr. Nanda also stated that he has recommended the patient to go for surgery operation.
And the doctor has recommended the wife of the petitioner.
Treatment of the patient further verified from the attendance register of the clinic.
For surgery. The document filed by the Land Counsel for the state is taken on record. ତା ବାହାର କରି ପ୍ରିଣ୍ଟ ଆଉଟ୍ କରି ରେକର୍ଡ ରଖିବ ସେ ଯୋଉଟା ପଠେଇବେ ହେଲା. Considering so-and-so 1 month bail granted, IA disposed of. So you will file the surrender certificate. Yes.
May I play another thing, my lord? Since he has served half of the substantial punishment, that is 10 years, the registry be directed to publish the paper book, prepare the paper book.
2019 appeal cannot be taken up. Old appeals are there. You can if you show that you surrender at right time, then half of the punishment you have served, that can be considered for 3 months bail. But show your conduct in surrendering at right time.
Well, earlier he was released on bail.
It's all right now. Yes. Now it will be untested for another time. 1 month bail granted. IA disposed of.
3 months. 3 months.
1 month. Surrender certificate to file. Health check-up by you. Yes, next.
Item 63.
63. I am handing over the copies of declarations to Mr. Mishra.
The Land Counsel for the
Item 68.
My lord, I am through virtual mode. Lordship, this is criminal appeal. Lordship, there are two matter fixed, one for Malay Swami and one for D. Salam. I have filed the power for Malay Swami. Lordship, it's an appeal under section 374 CRPC, and I'm in JC since July 2019. And there are two IE has been filed, one for the bail, regular bail for the suspension of sentence, and that is number 1080, and 1081 is for stay of the fine, realization of fine. Lordship, if we see the impugned order, there is, in my limited knowledge, there is sufficient material to suspend the sentence. And
Yes.
There is sufficient material to suspend the sentence and to release him on bail.
Deposition
order.
Sir, the deposition copy want to argue it on merit on the London State Council so that it can be taken off. The London Council for this is item number 68 and the first one, CRLA number 604 of 2021. The London Council for the state submits that he has not received the deposition copies of the witnesses. Mr. Sam Manohar, Land Council, appearing for the appellant, submits that he will supply the same during course of this week.
Yes, Lord. Yes.
During course of this week, list this matter in the week commencing from 14th August 2023. Along with Lekideve, CRLA number 605 of 2021. Yes.
May I please, Lordship? The appellant custody since 26/8/2016 till arrest. The conviction of 10 years and fine 1 lakh. The alleged offense 20B2C.
Which application you are moving?
Both the
application. In the first one, there is no interim application.
No, ma'am.
So what moving? Second, you can move the bail application is filed. So 616 of 2022, the appellant second of 616. Okay, in 616, as it appears that you have filed two interim application, one for bail, the other is for stay of realization of fine. And it's a case where you are being found guilty under 20B2C, right? Your name is Keshav Kumar Ture. Okay. So Keshav Kumar Ture, as it appears, he is in custody since 26/8/2016, right? And sentence imposed is 10 years. So you have already undergone 6 years and 26/8 মানে 11 মাস ହେଇଯିବ। ଆର ମାସରେ ହବ ଆଉ ଗୋଟେ ବର୍ଷ ପଡ଼ିଯିବ, 7 ବର୍ଷ କମ୍ପ୍ଲିଟ ହେଇଯିବ। ତେଣୁ 6 ବର୍ଷ ସରିଗଲାଣି, 6 ବର୍ଷ 11 ମାସ। So 10 years. Yes, what do you say? 6 years 11 months he has remained in custody. And is a local man or outside?
Outsider, Chhattisgarh.
Then you obtain that instruction. The faster kichi darkar nahi, secondary. CRLA number 616 of 2022. IA number 1180 of 2022. This is an application for bail. The London Council for the petitioner submitted that the petitioner has remained in custody for more than 6 years and 11 months. Alright, you just write that date. Is in judicial custody since 26/8/2016, 26/8/2016, and as such he has remained in custody for a period of 6 years and 11 months. And since there is no chance of early hearing of the appeal and and it is an appeal of the year 2022, the bail application may be favorably considered. Subpara. The London Council for the State, on the other hand, submitted that since the petitioner is a man from Chhattisgarh, he may be given some time to verify whether the address furnished by the petitioner in the cause title is correct one or not. Usual order kariba. Superintendent of Police Koraput will make necessary communication with Superintendent of Police Kanker district in the state of Chhattisgarh. Report where 2 सप्ताह ପରେ ପକେଇଦେବେ। Yes, address verification.
Item 72.
Wait, please, my lord.
Stay of conviction.
Yes, my lord.
So,
What a fine melody.
You have placed your note, your written note of submission. On what ground you are seeking for? What is that?
No, written note today I have not given, my lord.
No, you should give it.
I'll give, my lord. I'll just take a lordship for 10 minutes time, my lord. I'll not go deep into the matter. Because, my lord, to get a order regarding suspension of sentence or stay of conviction, my lord, it is like a diver going deep into the sea and trying to find out the pearl, my lord. My lord, now I have found out the pearl, my lord.
Yes.
That is my lord's judgment of 4th of July 2023, my lord. My lord, I'll just start with that judgment, my lord.
Yes, sir. So that's a different case altogether.
My lord, I'll come now. This is, I found, my lord, this is the only case probably where the ratio with regard to under what circumstances stays to be granted has been decided. Otherwise, my lord, prior to my lord's judgment, I had 2-3 other judgments. I'll come later on. Later on, I will cite this judgment first as to when a stay of the conviction can be granted. Lordship will only sees 2 paragraphs for my lord's judgment, my lord.
Yes.
Well, this is a criminal appeal number 208 of 2019. Sri Haricharan Das versus State of Orissa Vigilance.
Yeah.
Judgment of 4th of July 2023. Lordship may kindly come to page 17 of the judgment. Well, till page 17, in fact, your Lordship had dealt with various judgments cited by both the sides. And now, Lordship may kindly say, having regard to the aforesaid position of law, I am of the humble view that the conclusion arrived at by the learned trial judge while convicting the petitioner under Section 7 of the PC Act, that the prosecution has succeeded in proving the factum of demand made by the petitioner to the PW1 on 11 June 2013 suffers from total non-application of mine, as there is neither any charge framed to that effect, nor any evidence to that effect was adduced by the prosecution during trial. Without taking the pain of reappreciating the evidence on record at this stage, it is apparent on the face of record that the petitioner stands for fair chances of acquittal, and he has made out an exceptional case which convinces this court to exercise its jurisdiction under Section 389 of the CRPC. Ergo, in view of the fallacy discussed above, I am of the humble view that if the impugned judgment of conviction of the petitioner is not stayed by the time the appeal is taken up for hearing and decided, much water will be flown under the bridge, and the evil that would likely to befall on the petitioner in the meantime would aggravate, and it would be too late to set the clock back. I am of the further view that the petitioner has made out an exceptional case for stay and suspension of the conviction. It is one of the exceptional cases where the order of conviction should be stayed, suspended, otherwise it would cause irreparable loss and injury coupled with irreversible consequences, resulting in serious miscarriage of justice to the petitioner. Well, I totally will not rely upon this judgment. My lord, prior to my lord judgment, my lord, there are 2 other cases. Your lordship knows, my lord, in that 2014 volume 8 SCC, my lord, Shamnarin Pandey, my lord. In that case, what the Supreme Court said, that no hard and fast rule or guideline as to what are those exceptional circumstances. That is in paragraph 8, my lord. So, I was hovering around as to how to make out an exceptional circumstance, which has my lord judgment has made it so clear, my lord. And another,
Mr. In that case, the conviction was under Section 7 of the PC Act.
Yes.
But no charge was framed under Section 7 of the PC Act. That is one aspect.
Yes.
And the person was convicted for demand of bribe on a particular day.
Yes.
That is also not mentioned in that charge.
Right.
There is no evidence that on that particular day there was any demand.
Right.
And no question in the accused statement obviously has not been also asked.
My lord, that is what I'm exactly going to point out to your lordship, my lord. The scope of section 313, my lord, though that aspect was dealt with by your lordship, but there is no finding in fact on that. My lord, the latest judgment on that is AIR 2023 Supreme Court page 63, my lord.
No, I think it is also that type of case where we on that particular day about bribe also no question has been put in the 313.
Exactly, my lord.
That is there in page number 9.
Yes, but in fact there is no finding on that. Lordship,
no,
reflected.
Once I give the finding, it would be it should not be done because on the final hearing I have to leave something.
Yes. So I'm grateful, my lord. And now let me not cite that 2023 Supreme Court, page 63, my lord.
Here, it is also a trap case here.
Here it is, yes.
Yes.
No, it's not trap, my lord. It is, my lord, it is a...
What is this conviction?
My lord, it is, he was, my lord, the petitioner was working as a, my lord, as a marketing inspector.
Yeah.
And it was in the, my lord, some quantity of paddy was given to the miller to, my lord, ultimately for that is customized miller's rice.
Okay.
And there are 2 millers were given, my lord. And there are shortage found, my lord, when the miller's rice was given. For that reason, the petitioner has been implicated.
Okay.
Along with 2 others. Lordship, may kindly see this 2023 Supreme Court, my lord.
So it's a case of shortage of rice.
Yes.
Which was given to him, means entrustment is there.
Yes.
Are you disputing that no such...
Well, entrustment, that means it was entrusted to the millers.
Okay.
And millers also, my lord, have been cases instituted against the millers.
Okay.
And, my lord, those millers have admitted that yes, there has been shortage. But those admission of the millers, my lord, has been dealt with differently by the trial court by saying that is inconsequential. And they have admitted to have given to have made short
No, what is the allegation against you?
No, against me is that well, I had misappropriated that rice.
No, if it is given to the miller,
yes,
not to you, what is your role in that entire episode?
Millard, my role is that I am to Millard give it to the millers, Millard.
You are Ajay? You are working Ajay?
I was working as Millard, marketing inspector.
Okay. Civil Supplies Department.
Yes, yes.
Okay. Yes.
Lordship, may I kindly see this judgment, Millard?
No, I'll go to... I'm just factual aspect unless I will clear.
Correct. Millard, their allegation is, Millard, that I did not keep the rice stock and no steps taken for inspection. And made some correction.
Suppose you are a marketing inspector of Civil Supplies Department.
Yes.
Okay, then you are working for a certain period.
Yes.
Then as I find from the judgment, you purchased paddy.
Not purchased, procured.
Okay, procured.
It was procured and given to the millers, Millard, for the purpose of the customized rice, Millard.
Okay. So...
And what the 7 allegations against me,
that
I did not keep the rice stock and I had taken no steps for inspection. And I made some correction in the computerized statement by writing relevant date as something else. And as if I have also incorporated certain things, Millard, in the stock register. Thereby manipulating the entire thing, and there was a loss to the government. And the conviction the conviction is based upon a material which was detected at the time and after the Millard, all the evidences were over. When the learned trial court was about to dictate, my lord, he noticed that document. Based upon that document, conviction has been made, my lord. Exhibit C, by 1.
No, we'll go through the first of all legal position. It's almost it's all right, but
Yeah, well, let me
unless I
take
give
a
the
lordship
factual aspect, it
Yes.
would not be.
Yes, let me take a lordship too. And one more thing, my lord, there are 2 places. And here
you do one thing, you prepare that note so that next week we can
my lord,
take up.
yes, I'll do well.
We can take up at a particular time, 2 o'clock, let us say, so that it would be better.
I'll do, my lord. Let's say only few more minutes. I'll take, my lord. My lord, there were 2 places. One is, my lord, Kusum Khanti. Another is Laduga. For those 2 places, my lord, I was in charge, my lord.
Okay.
And now the sanctioning authority, my lord, has given sanction for Kusum Khunti. There is no sanction for Laduga, my lord. And, my lord, the conviction is based upon the alleged misappropriation at Laduga. My lord, this is the number 1 striking, my lord, startling feature in the judgment. Number 2, my lord, there was an alteration of the charge. But when the charge was altered, my lord, I was not given opportunity under section 216(2), my lord. And when the learned trial court gives a finding that it was just a typographical mistake, so corrected. But, my lord, in the charge, my lord, initially the area for which sanction was given, my lord, that amount was put. That was the amount to have been, my lord, misappropriated. In the correction, my lord, the area for which no sanction was given, and that amount has been incorporated. I was not given chance of, my lord, for participating in a hearing for alteration of the charge. Second startling feature. The third feature is, my lord, conviction is based upon a document which was never during the time of the trial.
You prepared your main points, and in support of what evidence or what you want to show to me.
Right,
in that way, prepare. We'll take up this matter next week.
I'll do, my lord. I'll do it now.
So I'm keeping it on Tuesday, on 8th of because that will come in the supplementary list, and we'll take up at 2 o'clock.
Well, that's right.
Verify whether you are available or not.
My lord, can it be 8th, my lord?
Yes.
Yes, yes.
8th is coming in supplementary.
Yes.
We'll take up this matter
at 2 o'clock. Yes.
Heard Mr. S.S. Das, Land Senior Advocate, appearing for the appellant, and Mr. Sanjay Kumar Das, Land Standing Counsel for the Vigilance Department. Das submit that he will prepare a written note of argument highlighting the points on which the stay of conviction has been sought for, and copy of the same shall be supplied to Mr. Das in advance. On consensus of both the parties, list this matter on 8th of August 2023. Matter will be taken up at 2 p.m. He files a judgment passed in CRL number so and so, which is taken on record. We put a seal here.
May I pray?
Yes.
I'm filing only one citations which may kindly be kept in record.
Yeah.
2023-91 OCR, page 84. Your Lordship may kindly have a glance to the last page only one line. Page 98, last page.
19.
98.
98, yes.
33, paragraph 33.
Yes.
The appellate court should not reappreciate the evidence at the stage of section 389 CRPC and try to pick up few lacunas or loopholes here or there in the case of the prosecution. Such would not be a correct approach. Again, paragraph 34. In the case on hand, what the High Court has done is something imperceptible. High Court has gone into the issues like political liability, delay in lodging of FIR, some overwritings in the past information report, etc. All these aspects will have to be looked into at the time of final hearing of the appeals filed by the convicts. Your Lordship have also held like this in other decisions, which I have already filed, like Prithviraj Lenka and Pradeep Santi, which my learned senior was arguing.
He is pointing out that other case which I granted it. That was
That was a different case, my lord. I was present on that day. Our particular question was not asked on the either on 313.
He has been found guilty for an offense when no charge
has been framed. I have gone through that.
A demand date has been given. That is neither in the charge nor any evidence has been adduced nor any
313 statement has been asked.
In spite of that, the conviction is made for the demand of a particular day. So that is how it was done.
That was a different case, my lord. But this decision I am citing, it is a latest decision, my lord.
This is a better and stronger case than what you have delivered.
We'll see. Okay.
This decision may kindly be taken up on record, my lord.
But I am not going to those things at all.
Yes.
What my learned friend says with regard to that OCR judgment.
No, we are not appreciation is not permissible.
Exactly.
Exceptional on the that what in that case what has happened? Charge not. These are not required to be appreciated.
Purely fallacy in law.
No. My learned senior is referring to the evidence adduced by the witnesses. So those are the evidence. My lord, the appellant has been dismissed from service since long. But the application which has been filed by my learned senior on behalf of the petitioner, what are the exceptional circumstances when he has been dismissed from service?
He will argue on the on 8th of August 2023. All right. Yes. Next.
Only that line, decision line.
I have kept your decision, Mr. Das.
Oblige.
Yes. Ashit Kumar Jena, Mr. Devashish Panda, A.K. Parida. All right, pass over next.
Item 80.
Defect number 5D man state copy ଦେଇଛନ୍ତି.
Yes, I received.
Yes.
81 now. I don't know.
Yeah. 81 let the learner. What is this criminal appeal for?
Conviction under section 20B2C of the NDPS Act.
So why don't you give a copy so that it can be taken up tomorrow itself? Are you having the extra copy of the appeal memo? Give it to the London State Council. All right. The London Council for the appellant handed over the appeal memo. Mr. Das, please verify appeal memo along with the impugned judgment to the London Council for the state in court today. Accordingly, defect number 5D is removed. How is it defect nahi to? All right. It's a case of conviction. What is the sentence imposed? 10 years.
10 years arrived.
Okay. What is the name of this appellant? There are 3 appellants, right? So all the 3 have been sentenced to RI for 10 years.
10 years.
Under section 20B2C. All right. Hard admit call for the trial court record. Have you filed any interim applications for bail, etc.? All right. That's so. Admit. Yes. Next case.
Item 82.
I have some medical work. Item 87. After launch खाली आसू फास्ट ଗୋଟେ medical ଯିବି ଟିକେ କାମରେ after launch.
After launch ଡାକିବେ ତ?
ହଁ madam.
All right. ଏଇଟା କାଲି after launch ଡାକିବେ. ଆପଣ ରହିଛନ୍ତି ତ କାଲି? Mark it. So 87 will be called tomorrow after launch. ହେଲା? All right.
Madam.
93 also.
Yes?
93 also after launch, madam.
93
3.
after lunch. 93, 87 after.